Division, 4th Department. Hear ye, hear ye, hear ye. All persons have offenses before this court should draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 93, People versus Mancuso.
Good
Also
morning.
proceed.
Good morning, Your Honors. Ken Tyler for the People. Both briefs in this case are very thorough. I know the court's familiar with the record. If I could, I'd like to touch briefly on points 1, 4, and 5. As the panel's aware, our argument in point 1 is that the grand jury proceeding was defective by virtue of the fact that the People did not charge the jury with respect to the defense of temporary and innocent possession, and as a second component of that they did not present a complete picture of Mr. Mancuso's statements to law enforcement. The temporary and innocent possession charge, and we're relying on People v. Graham, a case from this court. There was certainly evidence that the People presented that Mr. Mancuso possessed the weapon on a prior date. I think that's tough to debate, and that he stayed at the apartment with some degree of frequency.
Well, do I have this right, the record right? He ordered all the parts to the gun.
Correct.
He built the gun. He possessed the gun. He admitted the gun was his on multiple occasions,
Correct.
right? And he knew it was illegal. So all of those things go to, do they not? Proof of his knowledge and possession of the gun?
They do. They're all relevant, and the point I would make in response to that, I think I have to make in response to that, is prior possession by itself is insufficient. Beyond that, it's what evidence before the grand jury, what evidence should fairly have been presented to the grand jury, and would a temporary and innocent possession charge, is there any view of the evidence that would have supported the giving of that charge? And it's our position that all of what you said is true. But the question is whether, as alleged, he possessed the gun on the date alleged in the indictment.
The possession you're talking about for the temporary possession, is it the possession when he went into the room with the officer and he picked the gun up temporarily and the officer said, no, don't touch, it previously told him not to touch anything. He touches the gun, put it down, and they put it down, I think, on a table.
Correct.
Right?
Yes.
Is that the temporary possession you're arguing should have resulted in the charge to the grand jury?
Well, avoiding any confusion is part of our point of why the temporary and innocent possession charge should have been given, because what you just described is the only evidence of actual physical possession that he had on the date alleged in the indictment. And to the extent that the People relied upon that or invited the grand jury to rely upon that, I think that reliance would have made the temporary possession charge particularly important. I understand. Yes.
Wasn't he a convicted felon? He couldn't possess it even at all, even temporarily, could he?
I mean, I think if he had legitimate lawful excuse for temporarily possessing it, I don't know that his prior conviction, for example, the facts in Graham, the defendant claimed that he interceded in a fight right outside of his house and he pulled the gun away for the safety of everybody involved. I'm not sure that his prior, if Graham had been a convicted felon at that point, I'm not sure that would have prevented him from invoking the temporary innocent possession charge under those facts. So I'm not sure that's a complete bar to seeking the temporary innocent possession charge.
Defendant Graham didn't have all the other factors that Judge Whalen mentioned at the beginning of this argument.
No, he didn't, but it was still a constructive possession case. I believe in that case. I hope I'm getting the facts from the decision correct. The police came later in response to a domestic incident call, found the gun stowed away in the wife's purse. That is a purely constructive possession charge, and whatever weight ultimately you might think of that proof, it's whether there's any reasonable view of the evidence that the charge should have been given.
Look, I agree with you that the defendant's possession, the indictment charged October 21st, right?
12th, I believe.
12th,
Your point is.
If he possessed it on any days prior, you're saying that under People versus King, a case that we had a few years ago, he can't be convicted of possessing it on prior dates, even though he made the gun, even though he made it constructively possessed it, he may have directly possessed it. The indictment alleges a certain date.
Mm-hmm.
And your focus, as Justice Whalen indicated, your focus on that date in question is on the moment he picked it up, just momentarily, those few seconds. What the people seem to be suggesting is that on that date in question, that he was charged with the 12th, he constructively possessed it earlier in that day, in that he lived there. He admitted to the police he lived there. The gun was in his house. He said it was his gun. So that's the constructive possession that they're relying on to convict him, not that temporary picking it up momentarily. I understand their argument to be. You're looking at it differently. You don't think that earlier constructive possession on the date in question is sufficient?
I'm not necessarily looking at it differently. I think there's two components of possession that the grand jury could have theoretically relied on. It's picking it up, the actual physical possession, and of course the people, as they acknowledge in their respondent's brief, we didn't have a complete copy of the grand jury transcript. They charged the grand jury on constructive possession. I think giving the temporary innocent possession charge would have helped clarify what basis upon which the grand jury would vote to indict, and of course this relates to the second component of our argument. Justice Lindley, Justice Whalen, you've pointed out the other ways in which he possessed the gun. His lengthier statement, the other components of his statement during his interrogation with Palladino, provided much greater detail of what was happening on the date alleged in the indictment. And his statements, his assertions were that the decedent actually possessed the gun and he was actively trying to get it from her own protection, and she was obstructing that effort. She was in a compromised state of mind, and that's kind of the nature of the statements that we submit should have been submitted. The panel's obviously
the other points.
Sure. The panel's obviously well familiar with that argument. If I could just spend a minute on the sentence. Mr. Mancuso was sentenced to 11 years imprisonment. Justice Ogden, your point is not lost on me. He's a prior convicted felon. But as to that felon, that was over a felony. That was over a decade old. That related to some asbestos issue, and that was a federal felony. It was nonviolent. The basis for the sentence cited by county court, they referred to, well, I believe he had guns here to protect his cache of drugs or something to that effect. I'm not sure the record really bore that out, and my point would be that as a non-predicate felon, an 11-year sentence is heavy-handed, and I think it's just, I want to be careful not to, his charge is intertwined with a tragedy, undoubtedly, but the sentence should be for the possessory count, and I think it's just important to take a close look at that and review it in that.
We'll take a look at that.
Thank you very much.
Thank you.
May it please the court, Dawn Katera looking for the people. In regards to the first point, Your Honors, obviously the standard to determine whether a grand jury charge should be given is giving the grand jury enough information to make an intelligent decision on legally sufficient evidence, and a defense should be charged if it would eliminate a needless or unfounded prosecution. In this case, the charge of temporary and lawful possession just didn't fit, because what the defense is trying to do is distill it to that one moment in time when Mr. Mancuso picked the gun up and handed it or put it down when the police officer told him to. And to rely upon Graham and cases like Graham, the facts are completely different in this case. In Graham and other cases cited by the defendant, it's a case where the defendant comes into possession of the gun through some kind of a accident, almost. In Graham, there's a scuffle, the gun falls, the guy picks it up, and it ends up in the house where he's eventually charged. That's not what happened here. And the scenario is much different. In this case, he told the law enforcement at the scene, it's my gun, it's illegal, I had it, I said I was going to take it, and she took it. And not only that, he tells Investigator Palladino a couple days later, I gave it to her for protection, I wanted her to give it back and she wouldn't, that's why it was at her house. I showed her how to use it, I built the gun, he knew where it was, and most importantly, and really goes against what the defendant's arguing, he introduces it into the incident. He takes it because he's saying, well, I'm going to take it because she's drunk and she's making these suicidal ideations, and he was going to take it out of there. So he removes it from the pantry, and she grabs it from him. So he actually possesses it and constructively possesses it because he lived in that apartment, or he at least stayed there for a period of time. None of these facts are utterly at odds with the claim. These facts are utterly at odds with the claim of innocent possession of the weapon. In regards to the sentencing, I'll just briefly, mostly rely on the brief, but I think the court obviously is aware this wasn't just possession of a weapon. This was illegal possession of a weapon that this defendant built, knowing it was illegal, that led to the death of a person. And the sentence, in our opinion, is justified. And in regards to any other issues in the brief, I'm happy to take any questions.
No questions, counsel?
Thank you.
Thank you.
Your Honors.
Case 94, People versus Mack.
Good morning. May it please the court, Dave
Why don't you hold on
Juergens.
one second, counsel, till your
Sorry.
opponent gets
Sorry.
situated? Thank you. Proceed, counsel.
Dave Juergens representing Mr. Mack. I'd like to focus on point one, rest on the brief with respect to points 2 and 3, unless the court has any questions. Under point one, we're asking the court to vacate this guilty plea under a totality of the circumstances. This was a same-day offer made to the defendant, and we've outlined 3 coercive factors that should be considered. The judge basically made a threat if he went to trial that he would be getting much more than the minimum sentence. The people would describe this as explaining a range of sentencing to the defendant, and I don't think that fits the facts in this case.
So, Counselor, you're saying that the judge threatened him with it, knowing that
It's-
the sentence was illegal? Is that your position?
The position is that by saying that if he goes to trial, he can expect to get much more than the minimum, that's a trial penalty, which is different than explaining to the defendant that, the minimum's this, the maximum's that, and, you take the risk if you go to trial. So I think it was more in lines of having a trial penalty expressed to the defendant.
But there is no question he made a mistake in the sentence. The county court or the criminal court judge made a mistake in what he told the defendant the maximum sentence would be.
Well, that's the third factor, which I was going to go in order because I think it's the most egregious, but I'll get right to that. It was erroneous when the attorney and then the judge twice on the record told Mr. Mack that if he goes to trial, he's facing a penalty of 30 years. And that's just not accurate because there's a statute that's cited in the brief, 7031EI, that if there's no felony higher than a C-level felony, the sentencing can only be 20 years. That's the cap. So in effect, the judge gave incorrect advice to the defendant, to Mr. Mack, saying that you can get 10 years more in prison than actually was the case. And
Counselor, you're correct on that, and however, the case law is that the plea isn't automatically vacated based on erroneous statements regarding the maximum sentence, and your client did not preserve this. He didn't move to withdraw his plea or to vacate this judgment.
I
Is it,
agree. I'm sorry.
So we have to reach it in the interest of justice, or does not the Lopez exception apply to the argument, your third argument you haven't got to yet, with respect to the involuntariness? The plea was tied to that of his co-defendant.
Yes.
And that your client made statements on the record that, or appear on the face of the record, that indicate he felt it was not entirely voluntary. He didn't want to take it, but his co-defendant's right there, and he couldn't take it, and there was back and forth, and your guy says, I have no choice. Is it your argument that those statements, that he had no choice, and that he was doing it because his co-defendant wanted to take the plea, those are evident from the record, and therefore your client need not preserve it?
Yes, it's a Lopez-type situation where the court should have known that there was a problem with the voluntariness of the plea on the record and had to conduct a deeper inquiry. And the court made some attempt to try and, well, aren't you really taking this because of the evidence, the weight of the evidence against you? And Mr. Mack maintain, I'm not going to destroy my co-defendant's ability to take this plea. I feel I have no choice. He said that repeatedly. And so then, in that situation, we would argue that you don't have to invoke interest of justice. It's a Lopez situation that doesn't require preservation. But I would go back, lastly, to the incorrect information about the 30 years. We would say that you don't need to preserve that error by making a motion to withdraw the plea, because Mr. Mack had no practical ability to make a motion based upon incorrect, because there's nothing in this record to show that that was ever corrected.
I agree with you on a motion to withdraw a plea, but he could bring a motion to vacate the judgment. He could bring one tomorrow, could he not? If his position was, geez, if I had known I was only going to get 20, it maxed out at 20 rather than 30, like the judge told me, I wouldn't have pled. He could bring that in a 440, but this, you have 3 separate legitimate grounds for why this plea was involuntary. And you're saying even if Lopez doesn't apply, when you have 3 reasons that are fairly evident that your client did not want to accept this or would not have pled, that you're asking us to reach in the interest of justice. You just don't have 1. You don't have 2. You got 3 legitimately.
Yes, we would ask the court to consider interest of justice. I would say with respect to a 440 motion, that might be precluded because everything that Mr. Mack needs is on this record, and I think the statute says if it's all on the record, you need to raise that on the direct appeal.
Well, what's not on the record is his thought process, like I would not have pled if I knew I could only get 20.
That's not on the record.
Right. But in any event, we understand your arguments here.
Counsel, can I ask a question? Just kind of a practical problem. I noticed from the sentencing, the maximum expiration date of your client's sentence is about a month away. Do I have that right? In other words, you get the remedy you're asking for, you're getting a new trial.
That was a risk that was discussed with Mr. Mack, and he authorized us to go forward with the point 1.
Wanted to make sure I understood this.
Yes.
All right, very good.
Thank you.
Thank you, Counsel.
May it please the court, Lisa Gray for the people. Good morning, Your Honors. With respect to the voluntariness of the plea, notwithstanding the lack of preservation, this wasn't a coercive environment. It was perhaps certainly a brutally honest environment. By the time all parties appeared in court in January of 2020, this particular plea bargain had been whittled away from 10 years to 7 years, finally to 5 years. On a reduction to the attempted burglary in the 2nd degree. This was an extremely beneficial plea bargain to Mr. Mack. Mr. Neal, his co-defendant, was present in court at the time. So as far as the contention that this non-severable offer created an untenable position for Mr. Mack, the record basically belies that claim. Mr. Neal, at the time of the plea, said, listen, man, you do you, for all intents and purposes, what he said. You have to make decisions based on what you need to do. Don't worry about me. And Mr. Mack certainly was not happy about the position he was in, but that doesn't mean his plea was involuntary. It doesn't mean that the Lopez needs to come into play at the.
Do you think Mr. Mack's statements about his feeling that he had no choice and he was doing this more or less because the defendant, his co-defendant, wanted to take the plea as well, that warranted some inquiry by the court into the voluntariness of his plea? Or was that something the court could just ignore and just continue on with the plea?
I think the court interpreted it as that Mr. Mack felt like the evidence against him was overwhelming. This was a beneficial plea bargain, and it was in his best interest to take that plea. I don't think that the court interpreted that I have no choice, meaning he was tied to, Mr. Neal.
Do you think the record indicates that the reason why he said I have no choice was because of the sentence?
No, because of the entire set of circumstances in terms of the strength of the people's case. This is a reduction, to an attempted Berg 2. He was getting the minimum on the attempted burg 2, which was half of what he initially was offered on the reduction. So I think.
Are you saying that his concern for the co-defendant not being able to get the plea, that didn't factor in at all?
I think it was certainly diminished significantly when Mr. Neal piped up and said, listen, don't worry about me, you got to figure out what you need to do. I mean, he knew, to be clear, Mr. Mack knew that Mr. Neal wanted to also plead guilty, but Mr. Neal kind of let his co-defendant off the hook, like I said, when he said a few times, listen, you got to make a decision based on what you need to do. And Mr. Mack, probably that was the one thing he needed to hear, because he knew that the evidence against him was strong. He was getting a very beneficial plea bargain. He was represented by very experienced counsel who could have moved to vacate this plea and who never did so, never preserved this issue.
Right, but when the co-defendant says you do you, that's not true. It really translated to you do us, because he can't do him alone. If Mr. Mack says, no, I'm going to go to trial, then the co-defendant's got to go to trial. That seemed to be weighing on the defendant. I agree with you. Look, his lawyer did a great job of getting this down repeatedly, and seemed to be an entirely fair sentence. But when that statement's on the record, it's just a question of should there be some inquiry into that issue? Not, well, are you pleading guilty because you're actually guilty or not? Are you pleading guilty on your own free will, or are you being influenced by your co-defendant, the fact that it's being tied? I don't know. That's it seems a little different than, I have never seen this situation before.
Admittedly, I haven't either, but as the plea colloquy went forward, Mr. Mack, he never, went back on whether or not he wanted to plead guilty. He answered the judge's questions succinctly. There was never long pauses where he needed to consult with his counsel. There was never, and you've seen these types of pleas where you get the feeling that there really is colloquy between defendant and counsel trying to really kind of get this person to plead guilty, and that wasn't the case. I mean, Mr. Mack wasn't happy about it by any means.
We've all seen those cases. That's not this case.
That is not this case.
And that's your argument, but part of your argument. But what this case is, it seems to me, is the defendant throwing up his arms and saying, I have no choice. I mean, that's different than the cases you're talking about. And the question is that we're going to have to deal with is, did the court do enough in response to that?
But none of his complaints or discussions with the court at that time was, gee, I don't want to plead guilty because I'm innocent, or I didn't do this. There was never that kind of colloquy that went up into this case.
Correct.
That didn't seem to be, to me at all, to be what he was saying. He had other concerns.
I mean, the other point I do want to bring up, and I don't think we've talked about this yet, is that Mr. Mack and Mr. Neal were getting the exact same offer. It wasn't as if Mr. Mack was like falling on his sword in order to let Mr. Neal, walk away with a non-incarceratory sentence. Those are traditionally the types of things that we see in these types of non-severable offers. That didn't exist here.
It's also a good factor for you that, unlike in the Court of Appeals case, a leading case on the tying the pleas, it wasn't a family member or child or parent or somebody like that.
Correct.
Which would create a little more coercion.
A little bit more of a coercive experience based on the relationship between the people. So again, I think that also goes to support our point that when Mr. Neal kind of shouted out in court what he shouted out, I think, again, for Mr. Mack, he realized at this point, you know what, it's in my best interest to plead guilty. He didn't say it like that, but I think that's exactly what the court interpreted when taking his plea. So
We'll take a look at that, counsel.
Thank you.
Thank you. Case 95, People versus Lathrop.
Good morning, Jonathan Garvin for Tante Lathrop. May it please the court. As the trial court observed, this would be an excellent case if the victim was a car. The court's observation highlights two fundamental flaws in the People's case that I'm going to address in turn. One, the lack of any evidence of intent, and two, the lack of any evidence of accessorial liability or community of purpose. The paucity of proof begins and ends with the victim in this case, Mr. Dixon, whose testimony about the shooting, really can really be boiled down to 31 words. And that can be found on page 241 and 242 of the record, where he's asked what happened. All he said, and he says, and I'm quoting, "I just heard gunshots, that's it. When I heard a gunshot, I just ran. I didn't know if it was for me or not, but I just heard gunshots and ran."
Right, and the fact that he ran indicates, he says he ran, suggests that he wasn't in the car at the time? I mean, is that the way you read that?
That's not just the way I read that, that's the way the court read that, because that was addressed at the motion to dismiss, where the court said, I'm having difficulty with just that fact, that there was no testimony that, quote, of bullets whizzing by his head, or hearing the clank of bullets on the car, and then the people came back, the prosecutor came back and said, well, what about with the first gunshot? And even then, the court said there was no evidence that he was in the car when the first gunshot was fired. And
Right, so that's the issue. You started out your argument by saying this would be a stronger case if the victim were a car.
right.
It would be a stronger case if Mr. Dixon was in the car, right? I mean, if the person, if there was somebody in the car when the car was shot at, then it would be a much stronger case of attempted murder.
It would be a stronger case, but it would not be the end of the case, but we don't even have the...
Is there a reason why it wouldn't be the end of the case? Because you still have to demonstrate intent of the defendant here
You still have to present...
No, go ahead.
Okay. You still have to present evidence of... Just because someone's in the car and shot, there's other circumstances, no evidence of the circumstance of the shooting, such as whether it was close range, whether, where it is aiming. If you shoot at a car and you're just hitting the tires, did it come close to a vital organ? So I'm just suggesting that there may still be some work to do to find that specific and actual intent to commit murder, which is what the people were required to prove.
But Counselor, the bullets hit the window. Couldn't the bullets destroy a couple windows in the car, right? The passenger window where he allegedly was sitting? The record's unclear as to whether he was in the car or not. It's not established, even though we've discussed that right now, that he wasn't in the car. Because didn't he say he didn't even remember what car he was in, but he was reading?
He was on the telephone.
Right.
He didn't remember what car he's in, but he didn't say that he was in the car. And this is what I'm just saying what the trial court found. He didn't say he was in the car.
But he didn't say he wasn't in the car.
He has to be, to establish,
No,
to make the case stronger.
Clarify the record, though.
Yeah, the record, he didn't say that, but that's not on the defendants to supply the evidence. The prosecutor had every opportunity to prove their case, and they even had a greater opportunity than most prosecutors have, because the reason why we can say that he wasn't in the car, because the prosecutor, in the middle of the direct examination, accused him of lying, and the court threatened him with contempt of court and perjury. And the prosecutor was able to have a private conversation in the middle of direct examination with an attorney present. So he came back, the prosecutor didn't do anything to clean up the record, to make a stronger case. The prosecutor could come back and say, well, there was no perjury charges, there was no impeaching with grand jury testimony. Your Honor, I need to treat it as a hostile witness. The prosecutor didn't do anything. So we have to assume the prosecutor was satisfied with the testimony, and it's not up to the defendant to supply it. And do you agree
the evidence is sufficient, legally sufficient to establish that your client was in that BMW that drove by? He was driving the car when a passenger with dreadlocks opened fire, fired 8 shots into the parked vehicle. You agree that there's more than sufficient evidence to establish that much, right?
I'm not sure if I heard the first part, but you're asking whether I'm disputing whether Mr. Lathrop was the driver?
Driver of the car from which the shots were fired. You're not disputing
I'm not
that?
disputing that.
Okay.
I'm just disputing whether he shot at that person.
Correct. So you're talking about intent for these crimes.
Yes.
intent to kill.
Rest, on the acting in concert theory as well.
Right, so he was convicted of 2 counts of criminal possession of a weapon second degree.
Correct.
What effect would your intent argument on intent to kill have on, though, is it not, because when we have legally insufficient evidence, we look to what's lesser charges he might be convicted of. He's in a car with a guy who's opening fire on a motor vehicle. You say that that may not be CPW second, would that not be CPW third?
The criminal possession charges were based on, the trial court found that, based on Ms. Pablott's testimony alone, Mr. Lathrop possessed a gun. And that was at odds with the other trial testimony, that by the time the car accident came, the shooting was done. But she testified that that she heard gunshots while she didn't say she saw a black object that looked like a gun. So there's a little bit of a disconnect of the main theory of the acting in concert, and whether Ms. Pavin's testimony alone would be sufficient for the CPW 2 charges. And she was impeached with a grand jury testimony where she said she could not tell whether the passenger or the shooter was the one holding the black object, and she somewhat disputed what she said in the grand jury testimony. But I think, based on an acting in concert theory, when there's no evidence that that Mr. Lathrop knew beforehand that that this unknown passenger had a gun, and there was a preconceived plan or a prior relationship or any of the other factors that are used to sustain accessorial liability, I don't see how he can be found guilty of criminal possession. And the case law is pretty strong on this point. And in terms of requiring the McDonald case, Ramos case, there was much more evidence of someone driving a car that didn't happen here. They didn't follow the victim to a particular location, to a bar or a parking lot. The defendant and co-defendant in McDonald's, they were boyfriend and girlfriend. The defendant and co-defendant in Ramos were best friends. They had been seen earlier during the day. And in McDonald, they were seen afterwards. And before the shooting, the defendant was in the bar for 40 minutes staring at the victim. And then afterwards, she got rid of the phone that they communicated with after the crime, got rid of the car that was used to drive. And even with all that, which none of those factors are here, this court found, I believe the court found that the evidence was against the weight of the evidence. No, in McDonald they found it was legally insufficient, and Ramos was against the weight of the evidence.
Counsel, with respect to the actions, once the car pulled away or sped away, and then we have an intersection accident, we have some vocalization of get out of the way, and is your argument that that is as susceptible of shock and surprise that the driver had that the shooting was taking place versus him in concert and attempting to speed away as part of a team or a community effort?
I think defense counsel correctly argued that that evidence is consistent with someone being startled and surprised about someone suddenly pulling out a gun and shooting at a car and then speeding away and maybe not driving as carefully as he could and getting in an accident and just being startled by the whole situation. And in any event, it's well settled that consciousness of guilt and flight is it's equivocal circumstantial evidence of guilt that can't really sustain the charges here. So I'm agreeing. So to the degree that there was flight and consciousness of guilt, which has also happened in Ramos and McDonald, where the charges were dismissed on legal sufficiency ground, I would say that it's even a greater case here because there was even less evidence.
Counsel, you should be mindful of your time.
Yes, Your Honor. I just want to address I guess 2 points. The 911 calls also didn't support the claim that that anyone saw, to make up for Mr. Dixon's lack of evidence, lack of, quote-unquote, reluctant, or I say resolute testimony because he's very consistent, but reluctant testimony. The 911 callers didn't show up to people's weaknesses in people's case. The first caller, Ms. Jackson, said she didn't hear it twice in a minute call. She was asked twice. She said, I didn't see it. I'm just here because this lady got in an accident. I'm calling the police for her. And this is after the shooting is over, so she's not an eyewitness. I would submit that none of them are eyewitnesses. Miss Jackson was around the corner with her goddaughter cleaning out the car, and she didn't have a good view. And she actually she didn't say, there's my son is running across and they're shooting at him. She got worried. She ran around the corner to meet her son and found that he was okay. But once again, she didn't testify that she saw the shooter fire at Mr. Dixon.
I think we understand that argument. You should begin to wrap up.
Okay, I just want to say one point about the sentence, just in terms of the court's further opinion or sentiment about the strength of the case, where there was what came out at sentencing and it came out in the pretrial motion is that our client had a history, a lifetime of intellectual and mental disabilities, and the court, before pronouncing sentence, said that he was taken advantage of to give someone a ride. Although he also said, that's no excuse, but if that was true, that would be a factor that would counter against a finding of intent if because of his language deficits, if we had any evidence of what plan was, he might not have understood what the passenger had in mind, assuming the passenger didn't come and point a gun and say, drive me somewhere, and he had no choice. There's just no evidence. We don't know. There's no evidence about any relationship between any of the parties that we would just be speculating.
We'll take that into consideration. Thank you, counsel.
Thank you, Your Honor.
Good morning. I'd like to begin by addressing the court's concerns as to whether or not Mr. Dixon was in the car at the time of the shooting. Initially, with regard to his testimony alone, he never says he wasn't in the car, and what he does say is that he was on his phone. And I think one thing that people are forgetting is the fact that he heard somebody say, yo, either just before the gunshot started or during the gunshot started. If he was, and clearly the car is what took the brunt of the shots. There was a minimum of 4 based on shell casings, and potentially as many as 8 based on the witness's testimony, including Dixon's. So you've got Dixon not saying he was out of the car. You got him in the car, on the phone, and hearing somebody say, yo. Now, I also think it's significant in placing Mr. Dixon in the car, who clearly was a reluctant witness. He was done with this, did not want to go any farther with this, but there was still a crime here. And for that reason, there was a reliance also on the 911 calls that were made. And I think they're really significant. And I think that they probably were very persuasive to the jury. Because although defense counsel tries to discount them, saying, well, there's no evidence that they really saw anything, clearly they saw everything because they described the shooter, at least 2 of them did, in tremendous detail. So these 911 callers clearly saw it, and they said that the car that the defendant, there's no dispute, was driving, pulled down this one-way street. And according to the police, there were no other cars on the street. 2 of the callers say the defendant stopped his car next to the car, and 2 of them said the passenger shot at the boy. So I think that given Mr. Dixon's testimony and the contents of the 911 calls, I think you have ample proof that Mr. Dixon was in the car and that he was being shot at. I want to stress that these shots...
Mr. Dixon makes a good point, though, is that it would have been the burden of proof, of course, on the people. And he says all it would take for the trial prosecutor just one question. Mr. Dixon, were you in the car when the shots were fired? One question. And doesn't sound like that question was posed to him.
Okay, so I guess I would submit, Your Honor, I think she got it out by him testifying, I'm in the car I hear, yo, shots are fired. I don't know exact, or if he says, all right, when he runs, but he definitely puts himself in the car and hearing, yo. If he's not in the car, it's difficult to comprehend how, so I think she got that testimony out. Go back and look at how difficult this witness was. I mean, I don't know if there was a prior relationship with the shooter, the defendant, whatever, but to say he was reluctant, I think, is an understatement. So, yes, the prosecutor didn't...
Counsel, let me ask you that. So let's say we agree that he was reluctant.
Yes.
And the record reveals he's reluctant. How does that play on a lack of proof, an insufficiency here?
I don't think it does, Your Honor, but I think it explains why that question was not asked when she already got him to admit the fact that he was in the car, he heard the gunshots, he heard somebody say, yo, at the time the gunshots were being fired. And he never says, I wasn't out of the car. If he said, I wasn't in the car, I was outside the car when it happened, then it may be questionable as to why the prosecutor didn't ask that question. But I don't believe the failure of the prosecutor to ask a question negates our proof. The proof is what the proof is. You've got 911 callers saying...
Let's say, and help me with this, let's say that there's enough proof that he was inside the car, Dixon was inside the car. Where's the proof in the record with respect to the defendant's knowledge that there was a gun in the car? It was a small gun, my understanding of the record. Is there any proof that he was aware that the gun was even in the car? Is there any proof that he had the intent as he was driving this vehicle that the shots were going to be fired at Mr. Dixon in the car? I mean, my focus is, where is the proof of the intent and his knowledge that that gun was there and that a shooting was going to take place? And it's all part of an agreement between the two.
So I think, I'd like to start with the fact that I think McDonald and Ramos are completely different to what we have here. The defendant's not a getaway driver. This is a drive-by shooting. And I think that if you're looking for something explicit to establish, exactly what the terms of what this drive-up was going to be, the people would always be in a position where they would have to flip the shooter to find out what did the driver know at the time. So because of that, we have to look to what are the circumstances on this. Clearly, there was a real, they're front seat, both are sitting in the front seat. He comes down from behind on a one-way street. He has to be going slow because of the fact that you've got 4 shots just pretty much destroying this vehicle. I think that it is reasonable to infer that if he was completely unaware, if this was not a plan, once that first shot was fired, something would have been done. He could have accelerated, he could have moved a little quicker, but what he did was, it's clear, based on the way the path of the projectiles, is that he went slow. He passed that vehicle at a slow speed. And then he bolted towards the intersection where the collision occurred. So I think you have to look at circumstances to be able to show a driver and a drive-by shooting intent.
So does this come down to his reaction time from when the first shot was fired? The driver's reaction was to continue to drive slow so that additional shots would be fired, and then an effort to speed up? I mean,
I guess I would say if
is the record really clear on that?
I think if you would say reaction time and what actions he took, then I would agree with you. And I think the record is very clear. You've got the rear window of the car being shot out. Then you've got 2 shell casings, I believe, were recovered from the back seat of the vehicle. You've got the passenger side, the driver's side front window being shattered. Then you've got 2 shell casings in the front of the vehicle. So we know that, this is not something that I think would be reasonable that he would have, once the first shot was fired, if he didn't know, I think the jury could have reasonably concluded this must have been the plan, that this was a target. There were no other cars. This was the only car that was shot up on the street.
Do we know what the speed limit was on that street?
It's a residential street in the city, one way, it's got to be 30.
Usually in these murder cases with intent, there's, I know motive is not an element, but there's usually some indication of why somebody would intend to kill somebody else. Was there any evidence here of a prior relationship between the defendant or his passenger and Mr. Dixon? Any explanation of why they might be, why our defendant might want Mr. Dixon dead?
So there was no direct evidence of a relationship, but I think it is curious and worth some thought, the fact that Mr. Dixon was sitting in the passenger side of his mother's vehicle. I think it would be reasonable to conclude that he was waiting for somebody to meet him. Now, what was going to happen at that point in time? He's around the corner from his mother's house, sitting on the side, sitting in a parked vehicle in the passenger side. I think it would be reasonable to conclude that there was an intent to meet up with either the driver of the vehicle or the passenger of the vehicle. Again, no direct evidence, but I do think it would be reasonable to conclude.
Counsel, would you talk to me about this court's failure to give the circumstantial evidence charge in light of what I hear you saying right now?
Because I think that there was direct evidence that the defendant was the driver. He was identified by the victim of the car crash, Ms. Pabon, as being the individual who was driving the Honda at the time of the accident. So you've got that. You've got, as long as there's any direct evidence, that full circumstantial evidence charge was not required. And I do think that since it was never in dispute that he was the driver, I don't believe that there was any basis for a circumstantial evidence charge. I would like to touch for one moment on his conduct afterwards. And I do think it's relevant in this case, because I think that had the defendant stopped, had the defendant taken some type of action relative to Ms. Pabon, as opposed to saying, get the fuck out of here, and pushing her car into the intersection, and either the defendant or his shooter displaying what appeared to be a firearm, had he done anything other than that, I think defense counsel would be using that same evidence as being indicative of the fact they did not have a community of purpose. So I think that his actions afterwards are very relevant to determine whether or not he shared a community of purpose with the shooter.
Last question for me, at least.
Sure.
If we agree with Mr. Garvin on the intent issue, what effect, if any, would that have on the convictions for the felony weapons offenses?
I don't think it would have any effect on the possession of the firearm outside of his home or place of business.
He got 4 years for that. I think he got 7 years.
I trust you.
For the intent. All right, so there's 2 counts of CPW.
I know, yes.
One was for possession outside his, that would have no effect on this.
That is my
right?
opinion also.
And then the other one, though, was intent to use unlawfully.
If this court finds that there is no evidence of shared intent, and we strongly disagree, then I do believe that that would go with the attempted murder charge. If there is that absence.
But it could be, they constructively possessed the weapon in the car.
Correct. Or if, should.
And they intended to shoot at a vehicle, not necessarily.
It would still be an intent to use unlawfully. Yeah, that's correct. And I don't think, I was thinking also too, the display of the weapon to Ms. Pabon to get her to move the vehicle, but I don't think that was specifically argued, below. So, but I do think there are arguments for both weapons possessions to survive.
Thank you.
Thank you.
Case 96, People versus Townsend.
Good morning, Your Honors. Clea Weiss on behalf of Lonnie Townsend. I would acknowledge that the Court of Appeals decisions in Pastrana and David have narrowed the issues in this case, but I'm asking this court to give special attention to the credibility of the officers for 5 reasons. The first reason is that the 2 officers' testimony at the suppression hearing was tailored to constitutional standards, one of them specifically saying that the search was a DeBoer Level 3 search. I think when officers are using legal terms of art instead of just describing what happened, that does call into question their credibility.
You're saying that the testimony was tailored.
That's correct.
There was some indication in the record, I believe, that there was some conversation between the officers in between the testimony. One was one day and then conversation, and the officer testified. And I think you raised that issue also?
That's correct, Justice Whelan, and that's exactly my second reason why credibility should be carefully scrutinized here. One officer testified there was a 7-day gap between the hearing. One officer testified 7 days before the other. The second officer to testify said that he spoke to that officer about his testimony and specifically about the issue here, the odor of marijuana. So we've got communication between the witnesses about the key fact in the hearing.
Well, tailored, isn't that just a nice way of saying they lied under oath? Because really what the issue is here is, did they actually smell burnt or unburnt marijuana? You raise some legitimate facts here which suggest that it was unburnt marijuana, because they'd just gotten in the car,
Correct.
and it was small vials that were closed vials and small amounts, and you suggest it's just not believable that they could have, from standing outside the car, you're going to be able to smell the marijuana. So in other words, you're suggesting that they just made this up to justify the search. They're lying. I'm not saying you're wrong, but let's just...
I am
Let's just be honest
suggesting
here.
that the officer's credibility there are some signs that maybe it is not credible testimony. I'm asking the court to take a look at it, and one of those reasons is that the marijuana that's recovered in the car, inclusive of its packaging, is 31 grams. It's a very small amount of unburnt marijuana. It is sealed in plastic vials, and those vials in turn are in a sealed plastic bag in the back of the car. That's an incredibly small amount of marijuana, and that the officers testified it's not just the odor of marijuana. They use the phrase strong odor, and I think that I find that to be incredible.
But further asked, though, doesn't he say somewhere between mild and moderate, or words to that effect, odor? In other words, I don't know that it was consistently strong odor.
His initial testimony was strong odor of marijuana, and I think just like using constitutional standards to tailor your testimony by saying strong odor, that's another form of tailoring the testimony in this circumstance. And there's another reason I would submit that their testimony is incredible, is if you watch the body camera footage, which is People's Exhibit 1 from the hearing, it shows, you can just watch the footage, it shows that after Mr. Townsend is handcuffed and he's in the back of the car, the officers begin searching the car. But not only are they searching the car, they go right in and they open backpacks and they open closed containers in the car. That's a clear constitutional violation. And I think when you're looking at officers who are willing to blatantly violate standards and search closed containers in a vehicle, okay, they're willing to do something a little bit illegal there. And I think that sheds further light on what are they willing to testify to at the subsequent suppression hearing.
These cases are always difficult for us because odor of marijuana, or it used to be, we see a lot of furtive gestures. Testimony officer says, yeah, he made a furtive gesture. And if the hearing court believes that testimony, all we read is the transcript. We don't see the officers testifying. We can't assess their credibility in that manner. They're in a better position to assess credibility than we are. So we're being asked to substitute credibility determinations for the trial judge, which was in a better position. And that's always hard. It's not, we have authority to do that, and we have done it, but it's hard to do it just on a transcript. That's what you're asking us to do.
I am asking you to do that, and I would acknowledge it's not purely on a transcript. This court can watch the body camera footage from both of the officers, which was the exact same evidence that was in front of the court. And to the extent that these cases now often have body camera footage in them, it allows this court to really have the primary evidence alongside the testimony.
Those cameras don't pick up smell, unfortunately.
That is correct.
And that's what we're talking about here. Did they smell marijuana? I agree with you. It seems suspect that they could have smelled it under these conditions. Very suspect. But Judge Moran heard it, and Judge Moran believed them.
And I'm asking this court to take a very careful look at that, and I have one more reason I believe the court should take a careful look at that, and that this is an archetypal pretextual stops that have been proven to be conducted in racially disparate manners. The officers testified that they're patrolling in a, quote, certain area, quote, looking for suspicious activities and groups of individuals hanging out on corners. Mr. Townsend was stopped for having a registration that was expired by 2 days.
But there's no dispute with that, right? I think the officers ran the plate, found out the registration had lapsed, and pulled the vehicle over. I mean, you're not disputing the fact that there was legitimate grounds for pulling the vehicle over and approaching the vehicle and asking for license registration, right?
I'm not, but I think there's an important part of the facts that Your Honor just left out there, which is that Mr. Townsend's vehicle is parked outside of a corner store, and they run the license plate while the car is parked, and then they sit there and they wait for him to get in his car and drive away. It's not where they walked up to him and said, hey, you know, your registration's expired. They had other options here, but they sort of staked out his car to wait until he drove it so that they had this pretextual reason to stop him and then conduct this search. And in conclusion, the Marijuana Regulation and Taxation Act is not applicable to this appeal, as the Court of Appeals held.
Counselor, but just to clarify one thing, you continually attribute the smell of marijuana to the sealed packets of marijuana, but it could have been in the car prior to that from other marijuana. Marijuana lingers, doesn't it?
That's correct. But Justice Greenwood, there's no testimony in this case that they saw anything thrown from the car, like if he was smoking a joint and threw it out the window before the traffic stop was initiated. There was no evidence to indicate that he was sitting in his car smoking at the corner store before the traffic stop was initiated. So there was nothing to suggest that the odor of marijuana could have come from anything else besides the sealed marijuana.
But you will go rent a car, you smoke marijuana in it, they're going to charge you, right? A rental car, because they say any smoking, cigarettes, marijuana, it lingers in the cars. So what I'm saying is, just because it was in sealed packets doesn't mean that it didn't come from another source.
I understand Your Honor's point, and I think that the way that the smell of marijuana has been used to allow these pretextual stops over and over again, the legislature put an end to that when they enacted the Marijuana Regulation and Taxation Act. They specifically banned police from acting in the way that they did in this case. That act came into effect just 6 months after Mr. Townsend was sentenced. And I think that that's a signal to this court that the people of New York, through their elected officials, frowned upon this type of police conduct. And that's another reason why this court should give special scrutiny to the credibility of the officers. Assembly members, when this bill was enacted, specifically discussed targeted stops like this one. And I think that goes to, how carefully we should analyze the officers' credibility.
Counsel, thank you.
Thank you, Your Honors.
Good morning. May it please the court, Meredith Smith for the people. Justice Greenwood, you stole some of my thunder. There's no testimony as to whether the smell the officers smelled was burnt, unburnt marijuana. The defendant could have gotten in the car after somebody else had smoked in there. He could have smoked long before. It could have been on his clothes.
Shouldn't there have been a question at the suppression hearing? You say you smell marijuana, are we talking about burnt marijuana or unburnt? And then we could have gotten to, because I agree, marijuana smoke can linger. I'm not talking about from personal experience, just from what I read in these cases. But that would be a question that you would think would be appropriate in that situation.
Certainly it would have been appropriate, but it wasn't asked here. And again, given the great deference that the suppression court is entitled to, observing credibility, observing the officers on the stand, I don't think that is a fatal hit against the lower court's decision here. Any other questions?
No questions, Counsel.
Thank you.
Case 97, People versus Jenkins. Proceed, Counsel.
May it please the court, I'm Tanya Plank for Melvin Jenkins. I'd like to focus on the Molyneux issue, point 1 of my brief. The evidence of the past incident that resulted in the criminal mischief charge between Mr. Jenkins and Ms. Diaz here was not proper Molyneux. The court admitted it because the court said it went to motive, intent, and to explain their relationship, but it wasn't relevant to motive. I don't see how the prior incident had anything to do with motive. And with intent, there's the line of cases, the Vargas line of cases, saying that if intent is readily inferable from the evidence presented, then it's improper Molyneux. And here, this was like the Vargas case. It was a he said, she said, and the evidence was readily inferable from the evidence that was presented, whether he broke in the door, whether or not he assaulted her, whether there was a gun. That was all readily inferable from the evidence that was presented.
Counsel, let's just assume for the sake of argument that we agree with you on the Molyneux violation. Can you address harmless error?
Yes, I definitely think that this was not harmless. The complainant had a prior conviction, and she also had orders of protection issued against her. There's no physical evidence that he assaulted her. She didn't have any bruises, any cuts, no medical attention. There was never a gun found or any ammunition. There were discrepancies between what she told the police and what she testified to at trial and to the grand jury regarding whether there was a robbery. There was no evidence of that and nothing about that in her testimony. There were no boot prints on the door showing that he kicked it in. I mean, there was an absence of no fingerprints on the cell phone that she said he threw at her. And then the jurors, they asked for readbacks of the testimony charges, the 911 call, and then they acquitted him of the top count. So I do think this error was definitely not harmless. If there are no other questions, I'll rest on my brief.
Thank you, Counsel.
Good morning again, Meredith Smith for the people. I think the court properly exercised its discretion in this case. In the first instance, the people had asked for admission of 3 different items, and the court thoroughly reviewed each request and in fact denied one. The one that was allowed was this call to RPD about a smashed window, stolen suitcase and keys, and certainly this is a domestic violence case. And the fact is that the victim obtained a no-contact order of protection against the defendant following this February incident. So it clearly was probative of motive, intent, explained their relationship, their past history.
The court gave a limiting instruction?
Yes, in fact, Your Honor, the record indicates that the court had asked defense counsel to draw up the limiting instruction. And I think we can then therefore reasonably assume that the limiting instruction that the court gave was that provided by defense counsel. So I think defendant should not be arguing against that limiting instruction at this point. Furthermore, there was no objection to the limiting instruction. There was no request for mistrial.
Look, I don't care, you have the best limiting instruction ever, but if the evidence shouldn't have come in, it's reversible. And that's their main argument. But I guess we have all these cases for domestic violence cases that seems to be quite liberal in allowing prior bad conduct in domestic cases to, quote, provide background information concerning the contact and history of the defendant's relationship with the victim. That, there's too many cases to even cite on that proposition. So it seems like in domestic cases, the bar for Molyneux evidence is a bit lower than in other cases. Would you agree?
Yes, absolutely. In fact, I think when I researched, I found almost no cases where this court overturned a decision like that.
Anything further, Counsel?
No.
Thank you.
Thank you.
Case 98, Key Equity of New York, Inc. versus Azam.
Morning.
Proceed, Counsel.
May it please the court, Michael Longstreet here. This is a case I've never seen before. Basically, we were here 2021. Judge Bannister, Judge Lindley, you were in on the panel. The court found that there were tribal issues of fact with regard to the interpretation of these documents, found that a trial was necessary. 2 years or 3 years later, we are ready for trial, and the judge makes a motion.
Didn't we find that discovery was necessary?
Go ahead.
Okay, we didn't say trial necessarily, we said premature, let's do some discovery.
Well, I didn't see that in the decision. I said, what I saw was there was an ambiguity in between the documents. When there's an ambiguity in connection with the documents, there's always a trial as a result in order to determine the intention of the parties. That's just Hornbook law. Nothing changed. Nothing changed in the testimony. There's still a conflict between the various parts of the contract. The only thing that changed is I raised an additional argument, and the additional argument is where the whereas clause conflicts with the decretal paragraph, the decretal paragraph normally controls. That wasn't raised the first time around, it was raised this time. Whether that creates a question of fact or not is certainly up to you. You have to look at the contracts. But
And that's what the judge decided, right? Exactly what you said, that the decretal paragraph controls.
No.
As opposed to the whereas.
the other way around. The judge said that the whereas clause took the,
I'll read you from it right here. A statement in a whereas clause may be useful in construing the rights and obligations. It simply cannot create rights and obligations between those arising in the body of the document.
that's her statement of law, but in fact, the whereas clause is the one that.
I'm reading from the court's decision.
I understand,
Okay.
and it does say that.
Right, okay.
But that's not what the whereas clause is the clause that tries to take this assignment out of the lease.
Right.
The decretal paragraph, the lease itself says this option is part of the lease. And that's the conflict. Is it part of the lease or is it not part of the lease? Is it additional or not? The lower court in the most recent decision says, well, it's accepted. This court previously found that there was a conflict between the two. And when there's a conflict and ambiguity, as this court found, it has to go to trial. So our position is it has to go to trial unless you found that the decretal paragraph absolutely controls.
And take a look at that, counsel.
The other argument that was not, well, that was dealt with by the lower court has to do with waiver. We found an additional claim, and that is where the plaintiff basically said, you take your gas station, I don't want it. That is clear, that's written, it's clear and definitive, and it's some evidence to support our claim, and we submit that claim should go to the jury as well.
Thank you, counsel.
It please the court, Michael Kawa, for the plaintiff respondent, Key Equity of New York. To Justice Bannister, there was initially a summary judgment motion way back when in front of Judge Paris. And Judge Paris indicated that he was denying the motion without prejudice and for discovery purposes, depositions.
That was my recollection, yeah.
Okay. So, and in terms of the whereas clause, Judge Carol Lunas said, importantly, the whereas clause in the assignment does not create any rights beyond those arising from the body of the assignment. It simply excludes a right possessed by Key Equity, the option to purchase. I believe when the court made its prior decision and said there's a question of fact, I believe that was based on the general principle of law that an option follows the lease. But just like any other general principle of law, there's exceptions. And Judge Carol Lunas, in her decision, found 7 or 8 different or distinguishing points and exceptions. Key Equity assigned all of the right, title, and interest and the assets related thereto for its proposed operation of a convenience store. She found that amounts to nothing more than any rights it had under the lease to operate the convenience store. It had nothing to do with the ownership of the real estate. The construction of the lease is bolstered by the fact that the assignment then expressly excludes the transfer, the right to an option to purchase. The option separately attached. The option was separately executed. The option contains, and this is an important point, that the defendant, appellant, never even addressed in any brief or argument. The option agreement contains its own specific assignment and assumption provision. So even if we have some dispute about what the assignment document said, there is no, and the defendant comes forward with no specific separate assignment of the option. There is none. And I think that's probably the most important point. You can get beyond, well, did it say this, did it say that? The fact of the matter is there's no separate assignment of the option.
Counsel, the Judge Carol Lunas' order was issued January 23rd of last year. Correct, didn't it?
Yes, her decision was January 18th, order
It was
January
entered,
23rd.
yeah. So and she directed the property be transferred by August 21st of last year.
That was in the amended order. There was an amended order.
Well, I guess my point is, no stay has been granted?
No.
So this property has already exchanged hands?
No.
It hasn't.
No, we've been waiting 7.5 years to buy this property.
So the order hasn't been followed?
Judge, the original order that was signed on January 23rd, ordering the defendant to specifically perform pursuant to the option agreement, that was never complied with.
All right, so the order from Judge Karolounis says, ordered that the closing and transfer of the real property located at 1135 Erie Boulevard, East Syracuse, blah, 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 from defendant as trustee of the revocable trust to Key Equity New York to take place on or before August 21st, 2023. That's the order of the court. You're saying that hasn't happened?
That hasn't happened.
And there's been no stay?
Well, it gets more confusing because now Judge Karolounis has become an administrative judge, so the case was assigned to Judge Lamondola. Because the defendant did not close on August 21st, per Judge Karolounis's amended order, I had to bring another contempt of court motion. That eventually found its way to Judge Lamondola. There were discussions. The defendant signed the transfer documents, the deed and the other transfer documents, delivered them to Judge Lamondola to be held pending this court decision on this appeal.
Okay. Anything further, counsel?
No, Your Honor.
Thank you. Case 99, and we will also call case 105. Chappelle versus Hernandez. My understanding is the appellant has submitted.
Correct.
Proceed, counsel.
Good afternoon. I think we're still quite morning. Good morning. Rebecca Cons on behalf of the adoptive parents respondents in this matter. It's clear from the record that the family court made the correct decision in terminating these visitations. Under the adoption agreement, the impetus was on the mother to make sure that these visitations were scheduled. She missed 4.
And there's a reason for that, isn't there? That the
Yes,
emphasis is on the mother, on her to do that.
Yep, because there's a history of her not following through. And even given the intervening issue with COVID, so even if you take those middle 2 out while COVID was going on, giving her the benefit of the doubt or whatever, she still missed 2 visitations. She missed the December 2019 visitation, and she missed the December 2020 visitation, which was going to occur in January of 2021.
Wasn't there some problem about the scheduling the January 2021, whether or not she knew about it?
Not checking your voicemail, I don't think is a good enough reason. The agreement included emergency circumstances, and that I don't think falls under emergency circumstances. It was her responsibility to make sure that she knew that the visits were going on. It's her responsibility to make the phone calls and make sure that she knew what date and time. It's not on Catholic Charities to hunt her down and make sure that she knew what was going on. And as far as the phone calls, she was supposed to do monthly phone calls. In 2 years, she did 5 monthly phone calls. These children need stability. And I'll leave it to the AFC to provide an update on how the kids are doing. But the evidence is clear that she did not follow through with the requirements in this agreement.
And the agreement's important for us to look at clearly, and but ultimately, it's what's the best interest of the child.
Correct.
Right?
Yep, so the enforceability.
Yeah, and to the extent that it's, if the court were to decide it's in the best interest of the children to have some contact with the mother still, whether it be maybe phone contact, there'd be nothing inappropriate about that.
Correct. There's a method to maintain that contact. But we would argue that the mother hasn't been following through, and it's just going to keep happening, and these kids are just going to keep getting harmed by this inability for her to follow through.
Thank you, Counsel.
Thank you.
May it please the court, Mary Beth Barnett, the attorney for the children. I'd like to address the appellant's reply brief in this matter, and she misstates both the ethical rules for an AFC and the facts of the children's wishes as presented in my brief. First of all, she...
Well, why don't you do this? Tell us then, what are the children's interests? What are their wishes?
In this case, the young girl has no memory of her mother and has absolutely no interest in visits. For the boy...
Could you also address phone calls? Any interest in phone calls?
There's no interest in phone calls because they don't have a strong bond with the mother. They don't really know her. And even the boy, who I laid out that he wishes to see his parents because he lives in a large household where there's other adoptive children, and they're going to see their parents. But he doesn't remember her. He doesn't have a specific wish to see this particular mother. And so it's almost like a storybook wish. It's a dream. So I substituted judgment in this case. That was my ethical responsibility, considering his level of maturity, his special needs, and his ability to make what the rules say, knowing, voluntary, and considered judgment.
Okay, when you use the word special needs, are you saying this child has special needs, and what are the special needs?
This child does have special needs. He's in a special need classroom at Red Jacket where he goes to school, and except for the time that he's been homeschooled, because he has emotionally disruptive behaviors. And I think that's the reason why he saw a therapist for, very much intervention on that side. And he simply doesn't have the capacity, which I considered, to be able to make a decision about being stressed, as was stated this morning.
So let me just get as clear as I can be, and
Okay.
forgive me on this.
Fine.
You substituted your judgment in the place of the child. The child wanted what?
Okay, maybe this is a subtle distinction, which I did lay out in my brief. He wants to see parents. He doesn't necessarily want to see this parent. Is that clear?
Well, yeah, it's somewhat clear.
Well,
So in other words, he's not articulating that he wants to see his mother.
Right, he's not articulating.
He's saying, I'd like to go visit parents because other kids are visiting parents.
That's
I
right.
think that's your argument.
That's right.
Yeah.
Well,
that's what I'm saying.
Is that what he said, or
Yes.
is that what you're taking? Because he's
No.
11 years old, he could say. Is
He
that what
could
he
say.
said? Right.
He did say. And I'm not misrepresenting that, or I'm not putting my own spin on what he said to me. I very clearly asked him if he wished me to report to the court what he was saying, and he did. And I very clearly asked him if he had a memory of his mother, and he said no.
All right, so I'm going to see if, and this will be my last question on this.
Yeah.
So you're representing the court in your conversation with the child, the 11-year-old boy who's got special needs and emotional issues he's dealing with, that he's articulated to you that he wants to see parents. He has not articulated to you that he wants to see the mother in this case. And you're substituting your judgment saying, allowing him to see the mother in this case because he's asking to see parents would be the wrong thing to have happen based upon your experience and your substitution of judgment. Do I understand?
Correct. That's correct. I'm asking the court to affirm the decision of the lower court.
I think I understand. I won't speak for the rest of them.
Well, just to be clear on the other child,
Yeah.
the other child directly said to you, he does not want to visit.
That's
He
right.
does not want to have phone visits with the mother. Is that correct?
I didn't ask her about phone visits, but she directly said that she has no interest in connection with this mother, so.
And did you ask the 11-year-old if he wanted phone visits with the mother?
I can't remember. I don't know for sure.
Did you ask him if he had ever spoken to her on the phone? It was testimony that she only made 5 calls. So did you ask him about those 5 calls? Did he know who he was speaking to?
That's a good question. I think that he is not clear about that. As I said, he has no memory of seeing her. If he's told this is your mother and he speaks on the phone to her, then, he would identify that. But there were, as was pointed out, there were very few phone calls. She doesn't make the phone calls.
But didn't Dr. Sanders say he had a really hard time when he couldn't see his mother, when the mother missed that January visit?
Right.
So did he have that hard time because he didn't remember her, or he just?
Well, I think he's told, you're going to go have a visit and you're going to see your mother. And then she didn't appear. So my impression is that he has the hard time because she doesn't come. But he doesn't have a direct connection with who doesn't come.
Anything further, counsel? Anything further?
I have nothing further if you have no other questions, and I'm assuming that you do understand that the rules were misrepresented in the reply brief.
Thank you, counsel.
I just have one question.
Sure.
How are the children now?
They're doing well. I think there's a new addition being put on there in a house that has a lot of children in it. They're enlarging the house. They're excited about that. And I think it's better since as time has gone on.
And when was the last time you saw them?
The last time that I saw the children was in August.
Thank you. Case 100, Adams Jr. versus John. I believe your opponent has submitted.
Okay, good morning again, Your Honors. Ken Tyler for Ms. Adams. I won't belabor the points in our brief. I believe petitioners below have not filed a respondent's brief. I would just point out that really one of the things I was troubled by, other kind of what I perceived to be the lack of findings by family court, was the lack of rapidity or urgency with which the court addressed Ms. Adams' jurisdictional claims. The basis for jurisdiction was temporary emergency jurisdiction. As I read the record, the petition was filed in March of 21 and the court issued a decision in November of 22. And to the extent that the court agrees with our position on that, it maybe would be worthwhile to say something to that point.
Counsel, with respect to jurisdiction, just if you could, there was an initial custody determination in this case.
There was.
Does that not establish jurisdiction?
I mean, correct me if I'm wrong, but I don't think any party below argued that or family court relied on any other basis for jurisdiction. My reading of the record was that the parties agreed that kind of the baseline home state rule no longer applied. Neither the child nor the mother had resided in New York for years.
When it comes to subject matter jurisdiction, we're not bound by what the parties are arguing.
No, you're not. I'm merely making the point that that wasn't the framework for any of what was found below. The child hadn't been there for years. The mother hadn't been there for years. The father, who was the party to the previous custody matters, rather than the petitioner here, he had not interjected his rights, and his visitation had been suspended indefinitely, and I have no record information that he'd ever attempted to exercise that visitation.
But didn't they say he had the right to seek visitation without the requirement of demonstrating a substantial change in circumstances? So wouldn't that suggest that the court was retaining jurisdiction since they weren't requiring him to meet a jurisdictional requirement?
Perhaps. I believe the prior order mentioned he could reapply, essentially, and I agree with that. That being said, I'm not sure the father ever, I don't believe he ever exercised that right. He essentially, he hasn't appeared on appeal. I don't know that he's exercising parental rights in any way ever since then. The child and
He
the,
appeared to really take no position in any of this. He just seemed
Correct.
to be a bystander. If we were to say that there's no jurisdiction, what becomes of your contention regarding extraordinary circumstances? If we agree with you, your first argument is no temporary emergency jurisdiction. Let's say we agree with that.
Yes.
And then we say, well, we're not comfortable enough that there was continuing jurisdiction. If there's no jurisdiction, a court can't do anything.
you don't go any further.
So then it's over and your client gets custody. We don't even get to extraordinary circumstances?
That's my understanding. Jurisdiction is the threshold
Right.
question.
If, on the other hand, we find that the court had jurisdiction some way or another, then we must address extraordinary circumstances and perhaps best interest.
And perhaps best interest.
If we get over extraordinary circumstances. So on extraordinary circumstances, do I understand the evidence correctly? I think you know the record better than I. The mother has never been arrested that we know of.
Right.
The mother's never been the subject of a founded or even unfounded report of maltreatment, abuse of any sort. The mother is gainfully employed. It's not like she was working all the time. That's why she had to drive back and forth. The mother has legal custody of 2 of her grandchildren in Kentucky.
That's my understanding,
It
yes.
appears that that was following a home investigation to determine if she was appropriate. Some court gave her custody. She raised a number of other older children, including one of these petitioners, and then another daughter who moved up there with the child in question. None of those children, the older children, ever expressed any concern about the mother as far as how they were treated.
Correct.
They were never in danger. They themselves never saw her do any drugs. You would think if the petitioner here saw it, he would have testified to it. Instead, he goes onto Facebook and under her Facebook, his mother's Facebook, and we have some undated, we don't know when there was some marijuana use, maybe some other drug use. That's what the petitioners are relying on, extraordinary, that and some allegation of physical abuse that was not substantiated at the hearing.
Really not clarified at the hearing, no.
Now, you don't know what occurred at the Lincoln hearing, but during the evidentiary portion of the hearing that was subject to cross, there was a petition that alleged it, physical abuse, but in the evidentiary portion, I don't believe there was any testimony that this child was physically abused.
No, because these witnesses wouldn't have direct personal knowledge of that, having been in New York.
Right. So in your view, there's clear evidence of marijuana use at some point in the mother's lifetime.
I think that's fair, yeah.
But in your view, is marijuana use, is that extraordinary?
No, and especially when we have a lack of definition of how often we're talking about these things, where it takes place, whose presence it takes place in. It's sort of the lack of clarifying information around these text messages that really concerns me. A lot of this is based upon text messages that, as you mentioned, petitioners or Facebook messages went and retrieved and attached that to a second petition.
Counselor, in addition to what Justice Lindley pointed out, doesn't the record reflect that the child was frequently left home alone for extended periods of time, that he was failing every class except for physical education, and that the Facebook evidence that was put into the record had screenshots of her discussing buying and selling drugs? Isn't that in the record?
I think those are allegations in the petitions. I'm not sure those.
That wasn't testified to?
I don't recall the contours of that being testified to with great detail by somebody that testimony should be attributed weight to, somebody with personal knowledge. Again, petitioners are here in New York.
But let's stipulate that the concerns raised reasonably by Justice Greenwood are true. The kid wasn't doing well in school, was left alone at home, mother's working. Parents use drugs, may even deal drugs. We're talking about extraordinary, not, those are all relevant to best interest. And I agree, I would disagree with you. And once we get to best interest, your client is on very thin ice. But.
She didn't testify. I have a problem with best interest if you get that far.
But is it really, like, kid doesn't do well in schools, left alone, latchkey kid? That's extraordinary, so we're going to deprive a biological parent of a child and give to a non-biological parent. That's what we're doing here.
Right. And I agree with you, and I get that would be my response as well. Those are circumstances relative to best interest, or circumstances that may be raised in a neglect type proceeding, but she wasn't confronted with any of those at any point in time. Those aren't extraordinary circumstances. One party might cite those when they're opposition to another biological parent, and we're determining straight best interests, but I don't believe those factors reach the level of extraordinary circumstances.
And could we send this back to do, oh, I'm sorry.
He's 17 now, correct?
He's 17 now, that's true.
And in this record, he was dropped to his knees crying when he was told he had to go back with mother instead of being with his brother. Is that true?
I believe that's what petitioner testified to, yes.
So mother still, what's the current situation though? I mean, we're well past, we're 2 years past this almost.
Yeah, I mean, that's part of the problem with the expediency with which this was addressed, in my view. I hate to speak for the AFC, I know she filed the brief. My understanding is that mom relocated here because she felt forced to by the way the proceedings went. The orders are being followed. She has visitation with the child. And he's 17 now, so.
She lives in Geneva now.
That's my understanding.
So this is all moot next January.
Correct, and that's part of the problem we're up against, yes.
So if she gets a favorable decision here, in her view, she's been deprived of her kid from when he was 14 to over 17.
Right.
And whether she wants to try to pursue any rights, assuming she were to win, and we haven't discussed or voted it, but it's, that justice delayed, which is the problem you brought up initially.
Right.
Judge Reed, at the outset, when there's a question of temporary emergency jurisdiction, as you indicated, that's supposed to be dealt with expeditiously up front, before you get to hearings and custody and extra. That was, it took 2 years. And so even if your client won, she lost. Even if she wins this appeal, she lost.
Right, right. She can never be made whole, and that need for an expeditious result, that's statutory, and that's to make any victory here meaningful is, I mean, that's not really possible anymore. And that's why I speak to maybe it's useful to remind courts about these provisions about, interstate communication under the UCCJEA. There were tools here that could have, for fact-finding, for whether good or bad for the mother, that could have been used and much more expeditiously for the sake of everyone involved.
Thank you, counsel.
Thank you.
Case 101 and 102, Hughes versus Copes. I believe Mr. Kerwin has submitted. Proceed, counsel.
Good morning again. Rebecca Cox on behalf of the appellant mother. As an initial matter, I'd like to update the court that these parties are back in court. They have a attorney conference scheduled for January 22nd.
And what's that all about?
There's conflicting petitions. I don't want to go too far. I did speak with her counsel yesterday. There was some insinuations that the father's possibly being overwhelmed with having 9 dogs and 2 kids. So the mother filed an additional petition, and we'll see where it goes. But as soon as I have, what?
If there's an order on this new proceeding, it renders this all moot.
It could, depending on what the results are, and as soon as we get any results, we'll notify the court.
I'm sorry, when was that was commenced on what date, 22nd?
They're having an attorney conference on January 22nd. I'm not positive the exact date that she filed her petition, but it has been pushed a bit because of, she had surgery, different attorneys being assigned. She's on, I think, her 3rd attorney.
You'll notify the court.
Yes.
Thank you. Proceed.
I'd like to argue that the family court erred in awarding the father sole custody in this case. The children need to maintain stability, and the mother was the primary caregiver since birth for both of them. We have two very similarly situated parents as far as financial capabilities. They both have some medical issues. The father's medical issues, his ADD, his anxiety, and his depression, he acknowledged that it makes it overwhelming at times to have, he has a dog breeding business, so he has upwards of 9 dogs in the house and 2 kids. Plus he has an additional 2 kids with another person. The court focused solely on the mother's bad acts and sort of played down the father's bad acts. He's had multiple orders of protection in favor of the mother. There were 2 other orders of protection, one against a girlfriend and a 17-year-old girl. So both sides have issues, but we'd argue that to maintain the stability of the children, that the granting of sole custody was an error. And if there's any further questions.
No questions.
Rest on our brief.
Thank you.
Good morning, Your Honor. May it please the court, Tom Leith for the respondent, Mr. Hughes. I think that the referee in this case knew these parties. He'd seen them, heard them over a year and a half. He was best positioned to determine their credibility, and essentially, I think that his decision should be given deference, and there were 3 things that were incontrovertible, probably at least. One is the incident in the Dunkin' Donuts parking lot where
The baseball bat.
with the baseball bat with Louis, which the appellant did not disavow and was reluctant to even admit that it was the wrong thing to do. There was also the fact that she engaged in persistent and significant parental alienation. After that incident in the parking lot, she kept the children away from their father for over 5 months. The court had to compel her to
This was all precipitated by the fact that the father had a child with another woman.
That's right, his second
It's not like there's legitimate arguments going back and forth, and he said, I mean, she was upset, unreasonably so, that he procreated with another woman, and this precipitated this attack.
That was
with a baseball bat, and then the hiding of the children from him. I mean, that's pretty egregious.
That's what the father testified to. That's what the referee found. This was his second child from this long-term relationship with the girlfriend that apparently broke up the original relationship with the appellant. And she, I think the credible evidence shows that she was not happy about this. And this was the impetus behind both the attack and the keeping the father away from his kids and vice versa. And then the third, just quickly, there was a pattern of unsubstantiated and self-serving allegations and accusations made by the appellant involving drug use and abuse in the house in front of the kids, accusations about the dog breeding business being unsafe and unsanitary, all of which were controverted by the investigation that the referee ordered. And I don't know anything about the new petition. I wouldn't be surprised if it were more of the same. But given all of those things and the fact that the referee did find that otherwise the father did have a house that was adequate for the adequate space, clean, he had decent employment prospects, and could care for the children just fine. So for all those reasons, I think that the referee's decision should be given deference.
Thank you, Counsel.
Thank you, Your Honor.
Case 103, Freitas versus Ahmed. We're going to wait for Mr. Moranto. He's appearing by video, I believe. Counsel, welcome. Can you hear us?
I can, Your Honor. Thank you.
And we can hear you loud and clear. Proceed.
May it please the court, Robert Moranto on behalf of the appellant. Your Honors, within the last 10 days, I was watching a football game, and on came a Carfax commercial. And in that Carfax commercial, an animated fox was speaking to a consumer and talking about how the history of accidents will affect the valuation of motor vehicles. and literally shows the valuation of the vehicle ratcheting down based on the fact that that vehicle was involved in an accident. Your Honors, that is the world that we live in right now, and this is a case that demonstrates that diminished value in real time. In this case, my client went in and was going to be trading in his vehicle and was provided a $22,500 valuation on his vehicle. At the time that the actual sale happened, and between the time of the contract and when the sale happened, the vehicle was involved in an accident with a repair bill of about $8,000.
Counsel, we're familiar with the facts of the case. Let me ask you this.
Sure.
Are you asking us to change the law in the Fourth Department? Because it no longer applies in the world we're living in. That's your argument.
I am, Your Honor, and I do believe that the Franklin Corp case, which was decided by this court, actually opened the window to that argument, Your Honor. The fact of the matter is that the restatement of torts and just normal tort principles hold that an innocent plaintiff should be made whole, and that's exactly what this court said in the Franklin Corp case. And in this case,
Counsel,
my client is not whole.
Yeah, counsel, we've read your brief and we understand that case. Your rule that you espouse here, would it not only apply if the plaintiff could establish that he or she intended to sell the vehicle at or about the time of the accident? In other words, you're not suggesting that somebody should get the decreased value of a vehicle as a result of an accident if that person is going to hold it, like I do, to 100, 200,000 miles. That would just seem to be a windfall for somebody like me, would it not? In your case, it's different because your client alleges, and there's some evidence, that he was immediately going to turn it around. And it might make some sense in that situation, but it was not going to make sense in all situations, or say a leased vehicle would make any sense there, right?
It certainly would not make a sense in a leased vehicle, Your Honor, and I would say that in our case, and the reason why I'm testing this principle on this case is because this is a case that really highlights what diminished value means. But I would suggest, Your Honor, that I am taking this a step further. And in that step further, I am asking this court to state that diminished value would extend to any diminishing value of a vehicle based on an accident, because that's the reality. And that's the same, those are the rules that are followed in the District of Columbia and in Oklahoma and in Indiana.
Wouldn't you need to know when the vehicle owner intends to sell? Because that diminished value is going to decrease. Like if I hold a car for 20 years, today it might be decreased $3,000. Each year it goes down, it might be $3 by the time I sell it. How would that work in principle?
Well, Your Honor, that's actually a wonderful point. And I think that the answer to that, that's a wonderful point. I think that the answer to that question is that the cause of action for diminished value does not accrue until the vehicle is actually sold or traded in. But it doesn't obviate the fact that you're going to have a situation where the value is diminished because of the fact that it was involved in an accident, and people know that. And I can say, confidently that the court, members of the court, if they're going in and buying a vehicle and knew that the car was involved in an accident, would have the thought that the value of the vehicle was diminished by the fact that it was involved in it.
Yeah, I agree with that, but I don't know if that's such a new, novel concept. Looking at the cases that Johnson versus Scholes, where it seemed that doctrine came about in 1949, I was reading some of those cases, and that argument was made back then. It's been made certainly in the more recent cases that this is not a new thing, that if a motor vehicle's been involved in the accident, when you go to sell it, you're not going to get as much. That's not anything that arises because of Carfax or within the last few years or even decade. That's been going on for a long time.
I would agree with Your Honor, except the difference is now is that information is readily available to the public by simply punching a VIN number into a computer system. In 1946, no one would know, and I'm not saying that's right, but the reality of life right now is, in 2024, is that all I have to do is take a VIN number, run a Carfax report, and get an idea and knowledge that the car was involved in an accident. And the immediacy of that is that the car is no longer has the same value as a similarly situated car with the same mileage in the same year.
I think we understand your argument, counsel.
Your Honor, should I address the issue of the notice to admit, or should I just?
You have a little bit of time, you can do that.
I'll just address that this is a red herring, Your Honor, that the record itself addresses the notice to admit, and counsel for the respondent knows that the $8,400 that was paid as a repair was paid directly to Capolino. There was no windfall to my client, and the sales record, actually at page 25 of the record, the record submitted by counsel specifically indicates that the check was paid directly to Capolino. The sales records indicate that there was no reduction in the price of the vehicle as a down payment. That's all red herring. That's why
Look, it's clear, I don't think they dispute that the money went over to the dealer. They're saying your client never had the car repaired like he claims he did.
Right.
Well, no, he didn't have the car repaired, Your Honor. The car had $8,400 worth of damage. That $8,400 was sent to the dealership who did the repairs. And then if you look at the sales record, Your Honor, you see that the exact same sales price and no additional reduction.
Why wouldn't you respond to the notice to admit then and just say, we don't admit that?
Right.
Why wouldn't you just do that?
Clearly an error, Your Honor, and it clearly should have been responded to. But the record itself that's in front of the court right now answers that question, and it's clear that it answers the question, because the records that are submitted by counsel show that the check was not sent to my client as requested in the notice to admit. It was sent to Capolino. And it also shows that there was no, Your Honor, in order for this to be believable, it would have to be that my client had got into an accident, was given $8,400, and then was able to pay the exact same amount for the car and use that $8,400 as a reduction of payment. It's not demonstrated anywhere. To the contrary, on page 27 of the record, it's clear that there was no reduction, no down payment. This just didn't happen, Your Honor.
Okay.
And my final thing is the argument that insurance rates are going to go up, and I understand that this could have a broad effect, and decisions don't get made based on insurance, the interest of insurance companies. And I would just suggest to Your Honors, to the extent that there's any concern over that, insurance companies could simply write exclusionary language for diminished value, and then insurance rates would not be affected, and then I'll rest on the rest of my.
Thank you, counsel.
Good morning, Your Honors. May it please the court. Brent Ryder for the respondent from Hinshaw and Culbertson. Just to start with the notice to admit argument, there was nothing argued in the lower court concerning the propriety of our notice to admit. Zero. Not that the notice to admit requests were improper, not that they contained mixed questions of fact and law. It was not until this appeal was filed that we're hearing anything about the notice to admit. The appellant should have responded to it. Instead, they failed to respond to it. They admitted the facts contained in the notice to admit, which is the 2014 GMC truck involved in this accident was not repaired using that $8,400. So now we're asking for diminished value of $3,000 when the car wasn't repaired for the $8,400.
He says that the documentary proof in the record on page 24, whatever page he cited, that shows that it actually was repaired, even though they didn't respond to notice to admit.
It does not show it was repaired. It says nothing about the repair. Zero. That's why the notice to admit was issued. Hey, let's get some clarity on these very simple, factual issues dealing with just money. How much was sent here? How much here? What is the diminished value claim? Very simple things in order to limit issues for summary judgment and trial.
If he's wrong on his overall legal argument, he wants us to change the law here, wouldn't it be irrelevant or moot or academic or all of the above if this argument on the notice to admit? We don't even need to get to that?
You don't even need to get to that. That is correct, Your Honor. If you're not going to change the law that has existed in New York for almost a century on property damage claims involving motor vehicles, then no, we don't need to get to that, because the appellant was properly compensated by his insurer for the repair to his vehicle in order to make him whole, in order to make that vehicle drivable and in a safe condition after the accident. And I do appreciate that the appellant is honest about what they're looking for. They're looking for a wholesale change here. They're not asking for one of the two exceptions that this court and other courts in the state have applied to diminution of value. Yes, Your Honor?
No.
Oh, it looked like you were about ready to ask a question there. So there's, the first is if the vehicle appreciates in value, and the second of I believe it was the Rosenfeld case where there was unknown damage subsequent to the original repairs that were caused by that accident, where you see something other than just the repair cost involved. The Franklin case did not open the door for this question for a complete wholesale change. That case was decided on those facts. We had a sports collector car. It appreciated in value. Nowhere in this record, zero proof, nothing by the appellant, that a 2014 GMC truck appreciated in value from the date it was purchased to the date of the accident. It's not there. And if this change in the law should happen, or the court believes it should happen, it should be left to the legislature to do that. They are the more appropriate body in order to make that change for the damage.
Or the Court of Appeals. Johnson versus Schultz, as I did the research on it, it's an appellate division case, but it's based on Court of Appeals case law, well established, still in existence today, on property damage in general, not just property damage to motor vehicles. That's what the appellate division authority is based on. So you say it could go to legislature, but the Court of Appeals could also do a common law.
The Court of Appeals could have a say in that. I think the Court of Appeals in that case would defer, considering the implications of their decision, to an elected body and representatives who are, subjected to voting and people. The last point I wanted to make, and we touched this real briefly in the brief, but Carfax has been around since 1984. Kelley Blue Book has had an online presence since the mid-90s, 1995. This information has been around for a long time. The Franklin case was decided in 2011. All this information was there. Unless there are further questions, I rest on my brief.
Thank you, Counsel.
Thank you, Your Honors.
Case 104, Patel MD versus Shinoy MD.
Good morning, Your Honors. May it please the Court. Robert Yaman of Adams Leclerc on behalf of the appellants. This appeal follows a series of motions that were made in 2022, and what we were left with was a liability finding on a summary judgment motion on a proposed counterclaim that had not yet been pled. And we have issues with the counterclaim itself and the procedural process and how we got there. Beginning with the procedure. So the parties made their respective summary judgment motions in December of 2020. The Justice Nowak made a decision on those summary judgment motions the following July 2021. A year later, the Respondents' Counsel filed a motion to dismiss under 3211A5 for the reason of payment. This was untimely. That's waived under the clear language of 3211E. And without notice to the appellant's trial counsel, Justice Walker, who had taken over the case, converted that into a summary judgment decision. And while he denied the summary judgment motion, he made a clear liability finding and said it was only on the issue and the amount of overpayment. And so then following that came a motion to, yes, Justice.
So he didn't just pull that out of the air, Judge Walker. He based it on, I guess what we would understand to be a neutral accounting that was agreed by counsel to be done of the parties' transactions over the period of time that they were, in business together.
The motion is based on, as the parties prepared for trial, the respondents hired an expert, the appellants hired an expert, and as they were preparing for trial, this untimely motion came. And we have multiple issues with that. And alternatively, that motion to dismiss asked for the court to allow an amendment of the pleading and let the counterclaim proceed. And what happened so the court essentially without notice to the appellant's counsel at the time, who specifically requested it in their papers, rejected the appellant's expert, credited the respondent's expert, who was not knowingly responding to a summary judgment motion, and now the parties are left for trial with this finding that substantially prejudices the appellant. And it's on a counterclaim that the legal theory has not even been articulated yet. There's a series of motions, they're all included in the record, there's briefs here. To this, as we sit here today, we don't know exactly what legal theory this counterclaim proceeds on, what statute of limitations might apply. Are there defenses available to this counterclaim now to the appellants? We have an issue where there's now a new judge, in this case Justice Chimes has taken it over, and we have this decision, and the decision clearly states that the summary judgment motion, which again was converted untimely, a successive summary judgment motion, that clearly states that it was only being denied because of the amount of overpayment, not that an overpayment was made. So where does that leave the appellants to defend against this counterclaim? If this had been raised 4 years ago, there could have been a record developed about voluntary payment. There's really no dispute that the respondents, Dr. Shenoy, was responsible for every year accounting for the net profits to be distributed to the doctors' practices, excuse me. We weren't afforded that opportunity, and because this came so late, there was clear prejudice. And
Well, your client, correct me if I'm wrong, just procedurally, your client already has summary judgment on the breach of contract for the option.
That's correct.
Purchase, right?
Yes.
And so that's done. Judge Nowak issued that decision. Nobody's disputing that.
Correct.
Is there a damages trial? Is there a damages portion to that cause of action that's coming?
Yeah, I'll represent to the court. I reviewed the docket yesterday. The trial, and counsel, you can correct me if I'm wrong, the trial is currently scheduled for May of this year.
Okay, so this talk about offset
Yes.
with these call contracts.
Mm-hmm.
The defendant overpaid. He made a mistake and was paying when Judge Nowak said he shouldn't have been paying. So that's what we're talking about, offsets and other, counterclaims, whatever. Those offsets are going against the money that the defendant may owe the plaintiff on the option cause of action? Is that what the offsets are for? Because what else is there to offset?
Yeah, well, I think that would be what the argument would be if the offset is, if it's allowed to proceed as an offset. And we've cited in our brief why we don't think it should be able to, because it arises out of the same claim to the complaint. So it arguably could be a recoupment, but it's seeking damages over and above what the appellants are seeking. But yes.
But if it's an offset, then it depends on the damages. What if there's, say, $500,000 damages on the options, breach of the option purchase? You can't get offset over and above that, right? You can't say, well, you owe me $900,000. It would just cancel out the $5.
That's correct, Justice Lindley, and that's actually what was argued on the motion to dismiss under A5/motion to amend is the respondents had actually argued exactly that point. They asked to dismiss the case entirely because their expert calculated that something like $900,000 was owed due to this calculation error. The error, by the way, I should say, that the appellants were taken completely by surprise by, because Dr. Shenoy testified in this case that he never included the call contract revenue into this pot of money that was then being distributed. So that's a change in position there as well. I just wanted to point that out quickly. But yes, that's exactly what the respondents had argued below, which was this amount's over and above, so we should kick this case out. The judge technically denied that motion, even though he found liability against our client, but allowed the counterclaim to proceed, and the counterclaim seeks affirmative relief, which in theory it could be awarded beyond that.
This is mind-boggling. I mean, that the plaintiff's better off having never raised that breach of contract claim to begin with. Like, both parties were under the misapprehension of what was paid for call contracts. And
it appears to be the
plaintiff thought he was, that it should have been included and wasn't. It was in fact included. Judge Nowak said it shouldn't have been included, and the defendant didn't realize. I mean, Wow.
And I don't think there's a dispute in the record that the respondents were responsible for that accounting annually and distributing the profits. I just wanted to point that out.
Anything further, counsel?
If there's no other questions from the court, I'll rest on the brief.
Very good, thank you.
Thank you.
Good morning, may it please the court, Matthew Garvey for Dr. Shenoy. A couple of points of clarification, if I could, to begin with. There is no trial scheduled at this point in time. Okay. I believe, Justice Lindley, you've identified very correctly where the claim stands with respect to the set-off. What happened, of course, is that both parties treated this as a motion for summary judgment. Both parties had all of the financial information after Judge Nowak directed us to go ahead and begin to determine an evaluation of what the practice was worth, is when we had the forensic accountant come into play, which is exactly what the defense did. And both parties had their forensic accountants examine the books and records that had gone back in time during this, I'll call it a joint venture. And that's when it became apparent that an overpayment had been made, a substantial overpayment, because my client's a pretty good doctor, he's a terrible accountant. And what ended up happening was that both experts agreed that there was we called it an overpayment, they called it an overstatement. But in either event, both parties acknowledged that the appellant received money that they were not legally entitled to. We couldn't have known this until we had our forensic expert get into it. And ultimately, Your Honors, this would come out, one of the claims that survived was a claim for an accounting. So this is really just bringing about an accounting and allowing us to present what we found occurred during the parties' joint venture is that an overpayment had been made, and a substantial one. And yes, it would act as a set-off because the only claim that exists is the breach of contract claim looking for damages.
So as a result of all the motions, the only thing that happened was that the court allowed the counterclaim to go forward.
That's correct.
I mean, so really the talk about summary judgment motions, although we might think that they were improper under the CPLR, the fact is the court denied them.
That's correct, Your Honor.
So we're not in any different of a position, except that we have now, based on those accountings, requests that there be a counterclaim allowed, and that was granted.
And what this was, the counterclaim is only designed to allow us to be able to present that evidence that there was an overpayment made, and it can only be worked against the breach of contract claim that survived, and it can't exceed what the breach of contract damages would be.
And there will be a trial unless you guys resolve this case.
Unless we resolve it. But at this moment in time, Justice Chimes has us coming back in a couple of months, I can't recall when. And
Maybe
at
it's that
point,
May date that council.
there had been a trial date, and then that trial date was put off by Justice Chimes. And she said, no trial date at this time, we'll visit it after Your Honors have made a decision.
We have the issue of how far back you can go for the overpayments, the 6 years, the 3 years, and...
Well, if it's an offset, there's no end of, it goes back to the beginning of time.
If it's an offset, if it's a standalone counterclaim, then you want to go back 6 years.
Then we'd go back 6 years, and because it relates back to what the whole transaction has been. Since before the trial started, since before the summons and complaint was served, when the summons and complaint was served, and since that time, the call contract revenue has been the central issue between the parties. There was a significant amount of money involved in all of that. The appellant didn't want us to share in their call contract money. The appellant wanted to share in my client's call contract money. That ultimately got presented. Justice Nowak made his decision, said no, call contracts are excluded from the gross revenue of the joint venture. And then we had a legal determination that neither party was allowed to participate in the other's call contracts. That's when when we were told to go ahead and get the accounting, which is when it became apparent that Dr. Shenoy had unwittingly, over the years, been allowing the appellant to share in his call contract. And all we're asking for is just to allow us to resolve this matter on the merits, and that you affirm Justice Walker's decision.
Thank you, counsel.
Thank you. Next day.
Case 106, Thompson versus Peters. Both counsel are appearing by video. Mr. Byrd, can you hear us?
I can hear you, Your Honor. Can you hear me?
We can. Mr. Savino, can you hear us?
Yes.
And we can hear you. Please proceed, counsel.
Thank you, Your Honors. Your Honors, this case is fairly straightforward from our position. It's explained in our brief in the record, and what our position here is that we did everything that the order of the lower court regarding discovery had asked us to do. We identified specific docket numbers, which was initially set forth by Justice Nowak, who, as a practical solution to this matter, allowed us to, rather than produce these documents, identify specific docket numbers in this large record. We had did that, Your Honors, and based on that, we were in compliance with the court's orders. With respect to additional documents, we did produce additional documents with respect to a document demand requesting a computation of damages. We did produce documents. Those are on page 117 of our record. They're all identified, separated. They were provided in a Dropbox link.
Mr. Byrd, we read the record. Can I ask you just a question on the demand number 1 for documents? Document demand number 1 requested all documents concerning the formation, incorporation, and organization of the various corporations. Document demand number 2 requested documents concerning DBA certificates and so forth. Mr. Savino says those are never turned over. It would seem to be fairly easy. Well, number 1, were those turned over? And if not, why not? Those seemed, I get some of the other financial information is voluminous, hard, but what they're asking for in 1 and 2 seems to be easily turned, it'd be easy for you to attain and turn over.
Documents were produced, Your Honor. It's on page 246 of the record is where those business certificates start. We produced the documents that we had. I believe Mr. Savino is arguing that some were missing. These are the documents that we produced prior to depositions in this action that we had in our possession. But those are in the record.
Well, Counselor, he's alleging more than that. He's alleging that there was 10,000 pages of discovery that you did not specifically reference in your answers nor bait stamp, which is routine in a commercial case. Well, what's your response to that?
So my response is just to refer the court to the record, page 117. They were provided in a Dropbox link with each document separated. With this case, a lot of these documents are large bank records. That's why you look at the number of 10,000, it seems like there were so many documents produced, but each one of those documents was specifically separated in the Dropbox link and was labeled for what that document actually is. I think Mr. Savino's argument is essentially that too many documents were produced. But if you examine 117 onward, you will see that each of these documents specifically identified separate link in the Dropbox that could be clicked on separately to take you right to that document.
Counsel, let me ask you this. Are you there? Very good, you're still there, thank you. Do we have the actual responses in the record?
We have the supplemental responses are in the record on page 170.
It makes it difficult to review without having the actual responses in the record, wouldn't you agree?
I appreciate that question, Your Honor. The supplemental responses were in compliance with the judge's order. If you take a look at the supplemental responses, docket numbers were identified, additional documents were produced. So if you look at it from that perspective, we were in compliance with the court's order, which is what we're here for today on a motion to preclude. The initial documents were produced in the same manner, referencing docket numbers based on the court's decision on the motion to compel. Is when we went back through, we were refine the supplemental responses. We produced additional documents, but even if the court does not have the initial responses in its possession, if you look at the supplemental responses, they're in compliance with the court's order on discovery.
Mr. Byrd, what's your interpretation of the effect of this preclusion order from Judge Walker? There's a lot of cause of action, a lot of serious cause of actions with a lot of money on the line. Is there anything, do any of your causes of action survive this order?
In one word, Your Honor, this order, it's devastating for our case. Essentially, the complaint wasn't stricken, but essentially we're prohibited from offering any evidence whatsoever based on this order. And that's the main argument we wanted to make here.
It's then tantamount to dismissing the complaint is what your argument is. The preclusion order, if you can't offer evidence on your causes of action, that's what I'm hearing you saying. There's nothing left for you to proceed on, then the court might have well just dismissed your complaint as a sanction, which is drastic.
That's our overall position. And likely, depending on what this court rules, I'm sure there'll be summary judgment, but for all purposes here, it essentially ends the case here. And I would just point out that, and this is in our paper, but we've produced documents that the court may have overlooked, but the court essentially said you can't prove certain things when we've identified those documents in our papers that they were actually produced. But it's a drastic remedy.
So, counsel, let me ask you a question based on that. So we would have to find that the lower court abused its authority in this discovery order, correct? By favor. Okay, so then the next part is, say we were to determine that he did abuse his authority and we wanted to fashion a remedy saying that you should answer certain questions more directly. Based on what you're saying, is that even possible, or is your position is you've already answered, so us, specifying requiring you to specify more with bait stamps or specific references to the agreements would be futile?
Our position is that we've already complied. We've stated that we have no further documents in our possession. We've complied. Still our position that these documents are actually separated in the same manner that a Bates numbering would be. They are separated.
But if you're wrong on that, and we think you're wrong, that we feel you didn't comply, but we feel that the preclusion order is too harsh, is there some lesser sanction, is what Judge Greenwood, I believe, is asking.
Right, and I believe we had put this before the lower court, but I did put it in our brief that, a lot of times, situation like this, the court will prevent the introduction of any documents that were produced. That's a remedy that we're okay with at this point, that if we did not produce a document, we can't rely on that in a trial in this matter. But I think, to order this drastic remedy, I think for this court to go back and correct that would be for what I just mentioned, rather than essentially striking our complaint.
I think we have your argument, counsel.
Thank you. Can I make one more quick point, Your Honors?
Quickly.
Even if there was non-compliance with this order, I just want to point the court to a Fourth Department case. It's cited in our papers, the Miller versus Kastner case, that says preclusion, drastic remedy that is not warranted prior to party depositions. We haven't had them. So thank you, Your Honors.
Okay, thank you, counsel. Mr. Savino.
Yes. The theme here has been teed up. Can you produce too much? To just do a data dump, I think it turned out to be 12,000 pages. To just do a data dump where things aren't tied to demands actually hampers our defense. Yes, they can say, we're not precluded from offering this document because you had it, but how do we find it? When you look on page 117, there is an alphabetical list of file names. And when you look at the file names, they tell you nothing. Insurance, commercial, Kristen, expenses. This is drinking from a fire hose. It is actually destructive. This is the oldest trick of giving people noise, so it's unusable. And that's why it is possible to do too much production. It's done intentionally. It's done to drown me. Where do I go? Am I going to read 12,000 pages one at a time? Am I going to hire contract attorneys? They are supposed to designate. And what I really like is this panel has both Justice Lindley and Justice Whalen from the Ledgeretta appeal, from Justice Micklack. If you violate an order, there has to be ramification. This case involved 3 separate orders. 2 were violated. There was a motion to compel, that was violated. Then there was a motion to preclude where there were direct instructions what to do. That was violated. What we did to show how frustrated we are is we generated a chart tying out the respective demands to our criticism of what we got. We have to remember, whether you look at Ledgeretta or Martin or the other cases in our brief, like Santini, the standard is abuse by the motion court, and there was not. You've got to have ramifications when an order is violated. Now, Justice Walker made a point that this case started out about being Bank of America. It started out being about 7 bank accounts. This is not tantamount to dismissal. This decision says you can present all you want on those 7 bank accounts. You're unfettered on those. That's where supposedly the $500 million would have gone through. Those 7 bank accounts that survived. They can prove up the $500 million. But how do I try to analyze damages where all I'm told is $500 million would have gone through those bank accounts? Nobody tells me what the damages are on the quote lavish cars, the expenses, the alleged business takings. We're told nothing. And to try to work through this undifferentiated mountain, allegedly organized simply by file name. That's not organized by demand. That's simply they took what it got from Bank of America and flipped it over and sent it to us and said, there you have it. There's your production. And the important here is we may have concerns regarding the particular remedy. That should be the only thing before this court, because we had the appeal on the preclusion order from November of 22 dismissed in May of this year. So that issue is not in front of you. The appeal of the original motion to compel was never perfected. With the failure to perfect and the dismissal in May of 23, the only thing here is the extent of the preclusion. So there's no doubt there has to be preclusion. The question is how much gets precluded. And when you look at Gadley versus U.S. Sugar, which is not in our brief, but a fine case, 259 AD 2nd 1041, trial courts have broad discretion in supervising disclosure. In absence of clear abuse of that discretion, a trial court's exercise of such authority should not be disturbed. As you read these 3 escalating separate decisions, you see that Justice Walker is intimately involved, and he's sending an admonition in the motion, in the order on compelling under 3124. He says that failure can lead to an application for a sanction. He sends the warning, he throws down the gauntlet, and we get given a massive garbage. Heraclitus said the most perfect universe is a dust heap. I was given a dust heap. I was given undifferentiated. And I need to address something. The fact that the actual documents that are allegedly responsive are not in the record makes it exceedingly hard to rule in favor of the appellant, because the court cannot really assess what's been given to the defendants because you can't see it. Let me just check to see if there's anything else critical. Are there any questions?
No questions, counsel. Thank you.
Thank you.
Case 107 Conti versus Auburn Community Hospital.
Good afternoon,
Well,
Your
hold
Honor.
on a second, we're
Oh,
going to wait
sorry.
for, I believe, Counsel Wiley is going to appear by video. Counsel, your world is upside down.
I don't know why, I apologize.
I'm sure we don't know why either, but we can hear you. So if you can get that adjusted, that'd be great, but otherwise, we'll proceed with the argument.
Good afternoon, Your Honors. May it please the Court, Adam Mastrolio on behalf of the hospital.
Hold on a second. Counsel, are you still there?
I am, Your Honor, I don't want to be upside down on camera.
We'll give you just a few seconds to correct it if you'd like.
I don't know how to do it, but I'll be upside down.
Say, what was the last part?
I don't know how to do that, but it's fine.
Okay, very good. We'll proceed with the argument. Again,
Thank you, Your Honor. There are certain facts that are clear from the complaint. Plaintiff was a nurse, she was a floor nurse at Auburn Hospital, who worked in direct contact with patients. She requested an exemption from the New York State COVID vaccine mandate, which was denied. Plaintiff didn't request or identify any other accommodations. She doesn't in the complaint, she didn't then. We know those facts from the complaint.
And she was fired.
Correct. We also know that under the COVID vaccine mandate, the hospital could not grant the only accommodation that she requested, which was an exemption. So we know that
Well, there's no religious exemption, there's a medical exemption.
Correct.
But there's no religious exemption.
Yes.
Your argument is she asked for a religious exemption, we can't give her one, so she's gone. Her complaint, though, alleges that accommodations, there should have been some effort made to give her accommodations. She didn't ask for accommodations, she asked for a religious exemption. But the complaint alleges that she was discriminated against based on religion because once she asked for the exemption, your employer, your client just went straight to, okay, she's gone, rather than saying, well, let's see if we can accommodate her in some other position. That's what the complaint alleges. And does that not state a cause of action?
No, Your Honor, and there's a couple of reasons why. First of all, if we look at the federal cases, and I know I cited 9 of them in a very long string cite, but I did that for a reason, to show that the federal courts have been very consistent on this issue. The Second Circuit Court of Appeals has actually weighed in since the papers were submitted in a case called DeCuna. The site is 2023 Westlaw 7986441. But to your point, the way the federal courts analyze these claims under both Title VII and the human rights law is that where only an accommodation in the form of an exemption is requested, the hospitals can't grant that exemption. That in and of itself is enough to warrant dismissal of the case. And I'll read from the Denison case, which is one of the cases I cited. So the Denison case, the Denison court says, quote, although it may have been possible to accommodate employees by employing them in a manner that removed them from the mandate, they did not seek such accommodations. So the federal courts, they stop there with their analysis. I'm not saying that that's binding on this court, but I'm just using it.
So if this plaintiff had said, I want an exemption for religion, and in the alternative, I want some accommodations, put me in a job where I don't need a vaccine, she would have a claim.
That's not true, Your Honor.
No?
No, because, and here's the critical point, she's a floor nurse. In-person patient care is an essential function of her position.
But don't accommodations include, okay, you can't fulfill your role as a nurse, but we'll find a spot for you where you don't have to deal with people, not necessarily as a nurse, but some other paying position. Make some accommodations so I'm not on the streets with no money.
No, and the law, the human rights law specifically addresses that in the context of religious accommodations. Section 296, the executive law, subsection 10. An accommodation shall be considered to constitute an undue hardship if it results in the inability of an employee to perform the essential functions of the position. So, to the extent that a floor nurse who treats patients, an essential function of her position is to be with patients, then as a matter of law, giving her any other position that takes her out of that or eliminates that essential function is by law an undue hardship.
Well, I guess the other side would argue that through discovery, they may be able to find out, well, maybe she can be a floor nurse virtually, or there may be, she can do her job without actually coming to contact people. This is 3211, and you're just assuming that she can't do her job in any other way.
We're not assuming. What we are saying is that in-person patient care is an essential function of a floor nurse's position. And that is a matter of law. This isn't, we need discovery to find out what hypothetical accommodations may be available. I mean, there's also the case law that's cited in our brief in the disability context, where courts say that to even state a claim for disability discrimination based upon a failure to accommodate, you got to identify what the accommodation is.
What if, just hypothetically, in the records of a hospital, there are examples of floor nurses who had some kind of disability, where an accommodation was made where those floor nurses during the extent of the time of the disability were put into a room to analyze or do records, just hypothetically. And then the disability waned and they were back out on the floor. If there were evidence like that in the record, would that not allow for an argument that at least there should have been an effort to undertake or look for an accommodation if one could have been made?
No, our position would be no.
Okay.
Because of the essential function argument. The essential function is, I'm a floor nurse, I provide care to patients. Under the vaccine mandate, she cannot have contact not only with patients, but with any other staff member.
So even if a facility has, with a person that is referred to as a floor nurse, made historically, and there's records of it and examples of it, made accommodations for temporary disabilities, you're saying that even if there was proof of that, because the nurse, in this case, who potentially could be given the same advantage, you're saying that so what that it happens in the past, the definition of the job says is floor nurse, and that essentially requires contact with patients.
It's not just contact with patients, it's presence in the facility. Under the vaccine mandate, she can't be present in the facility. If you read that mandate, it's not just contact with patients. It's contact with patients, other staff members, or anyone else in the facility. So what you're saying, Your Honor, is so far afield of reality that I don't think it warrants.
It's certainly not the first time I've been far afield from reality. So, but thank you for answering the question. I think we have your answer.
Okay.
But Counselor, don't we have to wait, this is a 3211 motion, right?
Yes.
I mean, wouldn't these things come out in discovery, though, if the hospital were accommodating other floor? I mean, you're telling us they don't, but the other side doesn't know that, and aren't they entitled to that information?
The other side does know it.
We're talking about a cognizable cause of action.
I understand that.
Okay.
Based upon
I'm sure you do.
Based upon what's alleged in the complaint, though, there is no cause of action as a matter of law. And that's what I think the point is, and that's why I think that the federal cases are instructive. Those are all 3211 motions, or excuse me, 12B6 motions in the federal context. They're all motions to dismiss at the pre-answer stage. And the Denison court actually addresses what this court's talking about. So after they say that they're not even going to go further than what she asked for. She asked for an exemption, hospital couldn't grant an exemption, that's enough, case dismissed. In a footnote, the Denison court says, even if plaintiffs had requested accommodations rather than exemptions, it is hard to imagine how defendants could have accommodated them, given their roles as patient-facing nurses. It's the same facts here.
Was that case you're just reading from a motion to dismiss?
Correct, it's 12B6 in the federal context, but yes.
Yeah, because it would seem like you're making a lot of arguments on things that are outside the four corners of the complaint. In other words, she said, no accommodation, I was discriminated against because they failed to engage me with respect to any accommodations. You seem to be going outside the four corners of the complaint to say, well, we couldn't have given you accommodations. You're a floor nurse, and you got to come in contact. All this stuff outside, which suggests maybe summary judgment. Am I wrong?
The only thing outside the four corners of the complaint that we are going to is the text of the law and the cases that have interpreted that mandate.
All right.
Those cases have uniformly, the Second Circuit case in the We the People, the two We the People cases, which are discussed in the brief, very clearly say that hospitals, healthcare providers under the mandate cannot give exemptions based upon religious beliefs. There's one other.
Counsel, you should begin to wrap up.
Thank you, I will. There's one other thing I wanted to point out. You asked, Judge Whalen, you asked about the engaging in the interactive process. That's what they're really getting at. You didn't ask questions, you didn't look enough. But we cited the Gibbons versus State case in our papers, 206 AD 3D 974. And in that, I'm going to quote from that case, it says, "A good faith interactive process is not an independent element of the discrimination analysis under the state human rights law, and an employer may not be held liable based solely on its failure to engage in an interactive process with an employee." So if that's all they got, that we didn't engage in the interactive process to their liking, and that's the whole base of the complaint, according to the Gibbons case, that's not enough. The case should have been dismissed.
Thank you, Counsel. Mr. Wiley.
Good afternoon. May it please the court, Dylan Wiley on behalf of plaintiff respondent. Your Honor, at issue here is the hospital essentially implemented a blanket policy to take accommodations to anyone who requested an accommodation based on religion. And Ms. Conti was a victim of that policy. Regardless of how the accommodation is requested, even if it's unlawful, even if it's expensive, there's still an obligation on the employer to engage in an interactive process.
No, counsel just told us that all the case law says he doesn't have to do that. What, do you disagree?
I disagree. He cites Gibbons, but there's also case law, Phillips v. City of New York, that states if an employer does not engage in an interactive process that suggests discrimination. It's not an element of a claim. It's an important factor to be considered.
Counsel, I have to tell you, I have to stop you. You're breaking up, so I think you need to either get closer to your microphone or talk more deliberately and not move around. But go ahead.
There was no attempt here to, and if I could just reason by analogy, if someone with a disability in a wheelchair requests from his employer that they put in a lift in the building that violates a zoning law, and the employer then terminates that person, I think the question would be, well, could you have put in a ramp to maybe accommodate the disability? No, you just terminated him. Here, the law allowed for other options forward. Both We the People v. Hochul in the guidance allow for accommodations that take people out of the personnel requirement of the mandate, meaning people who do not associate directly with patients. At this point in time, we don't know, as Your Honor suggested earlier, we don't know whether there was a remote work position.
Well, counsel says you know.
We don't. We don't.
So you're suggesting that this interactive process could have yielded information that the nurse, the floor nurse, could have been, okay, you can't do that job, but we'll find something else for you in isolation, totally unrelated to nurse duties. He suggests that that's not even possible. You disagree with that?
I disagree with that, just because we haven't had a chance to go to discovery and see if it was in fact the case that remote nursing was not a possibility, what was offered to other nurses. No.
Anything further, counsel?
No, Your Honor.
Thank you. Case 108, Melsby versus Jermaine Jean Charles. Both counsel are appearing by video. Okay. Ms. Nosby, can you hear us?
Yes.
And my apologies if I'm mispronouncing your name. Would you help me with that?
Nosegby?
Nosegby?
Yes.
Okay, very good, thank you. And counsel, can you hear us?
Yes, I can hear you, Your Honor.
Very good. Proceed.
May it please the court, my name is Imada Nosegby. I'm the plaintiff appellant, and I'm here today for the oral argument because I wanted to make sure that the appellate division notes that the lower court erred because the two cases are not the same. Action number 1 and action number 2 are not the same. First of all, in action number 1, there's no mention of ownership of Fayetteville Smiles. Also, there's no mention of my name being removed from the documents. This case is between me and the two doctors, Dr. John Charles and Dr. Richter. And for some reason, the only affidavit produced is by Kimber Cummings, and she's not a part of this action. Secondly, they also mentioned text messages as documentary evidence, but the text message is actually written after the fact. And if you look at the records on page 57 and 56, the text message that I wrote was July 20th, and it says to remove me, and the answer that she gives is, she says it's already been canceled. And also the documentary evidence provided by the respondents on page 70 and 71, you can see that the application that was sent to the Department of State was sent on July 16. That's well before my text message. Furthermore, on page 64, the documents that were submitted to the Department of State on my behalf was sent June 8th, well over a month before they removed my name. And when I did ask about that, the document that I was provided had the names blocked out. So I'm just asking the court for a prayer of relief, for justice and fairness, that they reverse the order of the lower court, because this was a pre-answer motion. I didn't have any opportunity for discovery, and most of the stuff that they said was just based on the interpretation of the attorney.
Thank you, Dr. Nasopi. Counsel?
Good afternoon, Your Honors. May it please the court, Brendan Pelfman on behalf of respondents. I'd like to primarily rely on the briefs, but if I could just address 1 or 2 points, so if Your Honors have any question, I'm happy.
Of course, proceed.
Okay. With regard to the argument about the cases not being the same, the duplicative actions, I would just note that there is overlap of plaintiffs in the prior case, in this instant case, with Dr. Nasegbi being plaintiff in each, and there is an overlap in, well, not literal identity, there is an overlap between the PLLC plaintiff in the first action and the individual respondents here in the second action, who are the current and former owners of that PLLC. And I cited a couple of cases in my brief about the court having a broad discretion and that only substantial identity being required. With regard to the documentary evidence, I think you'll see that the text message that Dr. Nasegbi referred to, where she asked, she says she no longer wanted to be involved with the formation of the PLC, follows the conversation about articles of organization, and she follows up later on requesting again written confirmation that she was removed, that the process was canceled. And if you look at beginning at page 68 of the record, you can see that the articles of organization submitted without her name are dated August 3rd, 2020, after the text message. Unless Your Honors have any further questions, I'm happy to rest on the remaining of my brief.
No questions, counsel. Thank you.
Thank you, Your Honor.